Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Courtroom buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes, stand shadows cast. Whispers loud like wildfire spread. In this game, none's ahead. International eyes on the scene. Lines of right blurred and lean. Arrested dreams, shattered glass. In this court, who holds the past? Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. Families watch, soul torn apart. Courts drama quick to start. Chains rattle, futures bleak. Yet in silence, justice seeks. Around the world, eyes new gaze. Every trial a twisted maze. Judgment passed through smoky gates. In this court, no room for haste.
Hello, good morning, everybody. Sorry about today has been already a very eventful day. I am babysitting Anya today. Hello, everybody. And my job is a little bit messy already because I was trying to give her a bottle. She wasn't taking. She is a little bit upset today, but right now she seems very calm. But hello, everybody. How is everyone doing? Good morning. It's Thursday. It's Friday Eve. We've already made it, but to be fair, today it is a federal holiday. It's a holiday, so there's no much going on. Sorry, I might have to step back a little bit because baby's a little bit fussy, so I'm trying to rock her a little bit on the pram just to see if she falls asleep or not. But oh wow, we start the day with a bang. Josh, thank you so much for that. Oh my days, oh, I know, Baba. I know. But someone was very generous on stream. Thank you very much, Josh. Sorry, I have my niece here today. She's a little bit fussy today, but thank you so much, my days. Thank you so much. Thank you for the 5 gifted memberships. It's okay. It's okay, Anya. It's okay. It's all right. Sorry, thank you very much, George. I so appreciate that. It does help the channel a lot. Thank you so much. Wow, you are incredible. Thank you. But today we have, it's gonna be a small straight up stream because we have only a couple of hearings to catch up on. We might catch up on the stuff, but we'll see what Anya allows me to do today because sadly she's a bit fussy today. She's not very cooperative. But I forgot to say good morning to everybody. Good morning, Lois. Good morning, George. Good morning, Hannah. I want a cup of tea, Hannah, as well. And good morning, Cindy from sunny South Florida. Sherry, hey, good morning. Hi, my friend. So nice to see you. We did miss you so much this week, and especially yesterday. I was very concerned that you're not gonna be, watch the verdict. But yeah, I know. Honey, kind of says hi. She's side eyeing me right now, so I don't know if it is a good side eye, but it's so welcoming, everybody. We have some hearings. Thank you. Oh, I definitely need one. She's being extra fussy today. Good morning, Sissy. Good morning. Hi. Oh wait, hang on. I need to move myself because you guys can't see me when I put the comments on the screen. I might have to pick up her in a minute. She's um yeah, I don't know what's wrong. I out of practice, but good morning. Hello. Cindy, hi. Thank you for those emojis. And Cherry saying hi. I know. People are getting in. I know. It's very exciting. I think she's sleepy, but she won't go to sleep. So it's just that I've changed the diaper. I fed her. I think she's just fussy. I think she is having one of the days. She had her first shot the other day. She had her first baby shots the other day. Vaccines thing. So she's probably still a little bit fussy from that. And she's having a software update probably. But no matter what, it's Thursday. Um. Oh. Oh yeah, she's fighting the nap, Sherry. Absolutely, she is. Um, I know, I know. She is definitely fighting the nap. I did put her to sleep for a little bit. Um, Josh, that's probably burp. Yes, I have burped her twice. Um, so I tried to burp her. I can try to burp her again once we start the hearing. But thank you very much. Yes, Cindy, thank you for that. Um, maybe Josh, she's maybe fine. You got she's here on a background. Good morning, Denise. Hello. We need to know all about your experience. Okay, she's not crying. She's just public. Sorry. Okay. Hang on. I will stop being of a kid of my knees. I'll get over it eventually. But Denise, you were in court yesterday. How did it go? I know. I will pick you up in a minute, okay? In a minute, girl. All right. Okay. Good conversation. So um okay, I have to pick her up. 1 second. Give me 1 second. Was it too fast? I'm sorry. Sorry, I'm just with the baby on my lap. Hang on. Look. Like it's a baby here. I know, sweet baby girl is she's very upset with me today. I think she is upset with me because I made her do tummy time and she doesn't like that. Oh, I know. I know. I understand. We'll go to have a nap. I'll rock you in a minute. Yeah. Yeah. But so I think that's why she's angry with me that I made her do tummy time earlier. But I know we missed you too, Sherry. I know. Oh wow. I think everyone gained some weight with the stress eating with the long verdict. I totally understand that. But what's wrong? I need to go figure out what Annie is wrong. So we're gonna watch first. It's a short hearing, but ow. Thanks for that. It's for Rodney Hinton. He had a hearing yesterday. I don't know if you guys heard in this case, but Rodney is accused of unaliving a police officer that unalived his son. So it's kind of basically the story of this hearing. We're gonna hear it while I try to calm baby Anya for a little bit. Um, I know I'm talking about you, Baba. Okay, so let's just watch it. Going about where kind of about starts. Hang on. It's a very quick hearing. It's not a long one, but it's a hearing. Okay, it's very. There we go. I think it starts about here. So 1 second.
Just want to remind everyone, no cell phones in the courtroom. There are no cell phones in the courtroom. If you have a cell phone, turn it off. If you need to use your cell phone, go out in the hallway and use it. There are no cell phones, local rule, signs everywhere, no cell phones. Okay, we're going to call State versus Rodney Hinton. I think he's coming in.
I believe the judge.
I think they're bringing him in.
Okay.
I guess so. You can stand or be seated at a table with a deputy. What would you like? What's your preference? Do you have a preference?
Whatever Mr. Bennett wants.
What would you like?
We can be seated, Judge.
It's fine. We're here on case number B 2502219. I'm here for pretrial state versus Rodney Hinton. Mr. Hinton, how you doing? You're okay? Good. How are things in the Sonoma County Jail? All right, good. Is food any better? It's the same. Probably will be. Are your counsel coming to see you? I'm sorry? Okay, excellent. Good. Okay, so today we've got a pretrial. So several motions have been filed by the defense. A demand for discovery, a motion to preserve some audio video recordings, motion to appoint co-counsel, motion to compel, motion to exclude some photographs, motion for inspection of grand jury testimony, request for a bill of particulars, and a motion to suppress statement. So demand for discovery, has that been responded to by the state?
Morning, I'm Kip Gunn and Kate Burrows on behalf of the state of Ohio. We have received all those aforementioned motions. We have talked to Mr. Bennett, Mr. Bogan, as well as Detective Beebe. You may recall the last pretrial hearing, we came up with a scheduled timeline for discovery, where we told the court and defense counsel probably about 45 days for our initial response. We're still within that time frame. Detective Beebe is still compiling. There's over hundreds of body cameras and interviews. As I said, we talked just this morning with defense counsel about a timeline. We will get them to the next pretrial, which is scheduled for July the 9th. We have been in communication with Detective Beebe on the basis about updates on that. But we have received all those motions and we'll be responding appropriately as soon as we get that information.
Okay, that's great. I'm going to go through them one by one, so that's fine. I'm glad you guys are working together. Excellent. I love that. It goes smoother for everybody. Motion to preserve the audio video. Has that been responded to? Same answer?
Same answer.
Okay, thank you. And the motion to appoint a death penalty co-counsel, which I have done. I did that back on, I think, June 10th. Mr. Bogan, welcome to the case.
Thank you, Your Honor.
Thank you for taking this. I appreciate that. Motion to compel disclosure of exculpatory evidence. Same answer?
Same answer.
Thank you, sir. Motion to exclude photographs of the deceased.
Same answer.
Okay, and so, well, I guess you'd have to respond, but then I have to rule on it. Okay, motion for inspection of the grand jury testimony. Have you responded to that?
We'll be filing a motion in response to that and probably decide at a hearing. We thought it most prudent to respond to all these motions once we provide them discovery. For example, the photographs, we have not shared those with defense yet, so I don't know what they're objecting to yet, but
Good point.
we can address that down the road.
Very good point. Okay, thank you very much. And I'm abstaining for the bill of particulars.
Yes, Your Honor.
And the motion to suppress a statement. Is there a statement to be suppressed?
Not as far as I know at this point. If that should change, I will certainly get the defense counsel. We will get the defense counsel a copy and address that down the road as well.
Okay, so maybe, I know you filed these motions under an abundance of caution. Some of them sound like they might be a little bit premature. Would you agree with me, Mr. Bennett?
Yes, based on premature as far as the evidence that's been disclosed by the state of Ohio.
Right.
And my claim for the case, I believe those are going to be issues, and that's what the motion was about.
Yeah, which is totally fine. May just be a little premature right now. So is there anything you want me to do before the next pretrial date? I was thinking we'd set a hearing date for some of these motions. I don't know if you will be ready to do that in July or not. So that's where I am.
Your Honor, my suggestion with Mr. Bennett's approval that we just keep the July 9th date on. We'll get the discovery and address those issues and hearing dates on any motions that might be outstanding with regards to that discovery.
So not actually hear any of the motions on July 9th, just collectively come back together and see where we are.
Correct.
Excellent.
I
Okay.
believe that is all.
Okay, thank you, Mr. Bogan. Are you in favor?
I completely agree, Judge.
Ms. Burrow?
Yes, Your Honor.
Thank you. All right, we're all in agreement. Great. Is there anything else that we need to discuss? With anyone?
Not at this time, Your Honor. We'll get the information, Mr. Bennett, and Mr. Bogan, as soon as possible.
Thank you so much. Anything from the defense?
No, Your Honor.
All right, thank you all so very much. And again, I appreciate dropping off. I do believe there was a new motion. Thank you, Mr. Bennett, for dropping off. Really appreciate it. Getting copies hand delivered to us. Thank you so much for that. A second motion for demand for discovery, so I'll let you know that having been filed too. Okay, thank you all so much. We'll see you July 9th.
Your Honor, with regard to motions for continuance, we discussed them with counsel, and you know time is in the way already. I know it's often your practice to have the president court sign them, but due to Mr. Gates' circumstances, we didn't know.
Yes,
You wanted
they,
to sign them as well.
my entry. No, my entry.
Yeah, both?
Yeah, both. Yes, I do want them signed by Mr. Hinton each and every time.
Thank you.
Thank you so much. All right.
Wow, that was a great short hearing for absolutely nothing. Nothing happened. To be fair, I did not heard this one before today, because I wanted to watch at the same time. But if I had known it was a nothing bug, I would have not even bothered. But oh well, it is what it is. That's okay. Sorry, I have to have a bit of a background noise because I put some white noise for baby, and she seems coming down a bit, and she seems more thing. So I think that's all that she needed was a bit of a white noise background to calm down a little bit and maybe to sleep. Not white noise helps a ton for babies. I've learned that. Absolutely learned that, which was amazing. So okay, now, oh, someone is alive. Oh, but it's a different judge. Oh, it's our favorite judge, but one of our favorite courts. But yeah. So what we're gonna do is I'm gonna set up the Colin Gray hearing that happened yesterday, but we're gonna probably watch something new and something well out crazy hearing, a crazy hearing that Josh has. Josh has all the good stuff. You know how he is. He always finds the gems of true crime things for us to watch here and on the R8 channel, which is amazing. But let me open this one. It's the first defendant. That's perfect. So we can. No, that's not what I want to do. It. Hang on. What did I do? I pressed the button. Me pressing buttons. I cannot press button. There we go. I want the chair, but this. Nah. Sorry, just talking. So everybody thank Josh because this is his doing, not mine. I do not speak English. No, I'm joking. But now, shall we hear this hearing from Josh?
All right, the court, and I guess this is for one case. Court is calling 2024 CR 4295 State versus Luis Beltran. Can I have parties approach and announce for the record?
Yeah, wait for the Arlene Gay is the defendant.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have, yes.
Excuse me, did the court take judicial notice of the indictment in this case?
Yes,
Make its ruling, okay.
yes.
The
The next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? Do you have any questions about the court's ruling?
Yeah.
All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the Seventh Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without, abstract subject matter jurisdiction. And, the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the Seventh Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the Seventh Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 U.S.C.S. 841. This court now under federal questioning under Title 28 U.S.C. 1331. Light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing and to prosecute me, which is they're one of third party,
Okay.
and I'm not. I don't third party. I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant, They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So,
Guys, sorry, I just had to stop. I'm sorry, I'm out of breath because I had to go up and down. You won't believe I need to pull the footage of this on my camera, but I just had the police in my door. Sorry, I'm completely out of breath. Everything is fine, but I just had literally 2 detectives on my door asking for footage of my Ring camera. Only this is not. It's like everything is okay. I'm okay. Everything is fine. I need to pull that footage and show you, but I just had the police on my door asking for Ring police footage on my phone. I don't know what happened. It was only on the 6th of June that they wanted the footage from. It was a Friday, I think. I'm guessing that was a Friday, but I am going up and down those stairs with the baby. I do not recommend. Wow, I was scared. I was when I opened the door, and I opened the door and I saw police. I was like, oh, what did I do now? I didn't do anything. Oh, I'm hot. Oh, oh my days. Yeah, that was a Friday because oh my days. Oh, that's I don't know which day was that. Oh my god, this is so scary. Oh, I am just no, I don't know. Was it I don't know if it was the day that that guy was hanging out outside of the house because he did say 4 p.m. Which day was that one? This oh no, I don't think it was. Hang on, I think I know how to access that. That is crazy because it was when um oh yeah, obviously you guys are the first ones to know this. Gardenbot doesn't know yet. Cutie Pie is at work. He's doing gardens at I think I know, Anya. It's very upsetting. I know. See, even Annie is upset about this, but this is crazy. I'm like, whoo. But obviously, you guys know before a garden bot. This is oh, I know. I remember how creepy that was. I don't remember, and I don't have Oh, I have garden bots Facebook. Hang on, where's the phone? Is this the phone? Yeah, is this is the phone. My phone is there. Because I can go check which day we saw that. Yeah, I think she misses the ceiling fan. The white noise is helping, but this is scary. I'm sorry, but for me it is a bit scary because which day was um now that was on the 13th of June. Okay, that was on a Friday. Oh, good morning, Lydia. Hello, good morning. I need to pull the footage from that one, from that event. I know the creepy dude was on the 13th, so that was on a Friday the 13th. It was a bit scary. I'm not gonna lie. Having the police coming to my house asking for ring footage, of where I live, it is very very scary. I'm gonna try to pull the full footage from the Ring app and show you guys. There's no information that one. Yeah, it was on a Friday the 13th. I know it's crazy. Sorry, Lydia. We just see. Oh, I think the babies. Oh, good. Let me see if actually. Yeah. Okay, that's my sister-in-law going out. I want to share this video. Oh my days, this is crazy. This is some crazy thing out of a trial. You hear can you believe if I'm called? Because the thing is, I cannot disclose. The police asked me to not disclose, like, what I found on my camera. I can show you the conversation I had. I did not find anything, but they might come back again. So this is crazy. So yeah, fantastic. Hmm. Okay, I need to share this to my computer. So talk about true crime up front and personal. Oh, and then this is the road heels. I'm asking for pickles. He was cute. He was cute. I'm not gonna lie. That I only saw that one detective. I'm assuming is a detective. He was not in a police uniform. He had a lanyard, but there was a lady. And now I see the footage. He catches the lady as well. Because I did hear a lady as well, but he was. Hang on. Let me email this. And I know she's the most asleep, guys. Let me email this to me, and then I can try to show. Hang on, that's one, and then that's the other one. Hang on, bear with me a moment. I'm trying to send the footage to my email so then I can just download it. But it was some stuff. Let me see if the other camera caught. Oh yeah, the other camera caught them coming. Yeah. Ooh, this is our own true crime show all right here. See, more authentic content. There isn't. See, this is some good stuff right there. Sorry, we'll play the Judge Boyd in a second, but I had to tell you guys. I will tell Garden, but I'm fine. Everything fine. The door is now locked. So wow, this is crazy. I feel. Oh, I know. It's when I opened the door, I saw the police. I even made a joke. It wasn't me. I was like, yeah, it wasn't me. And he kind of laughed. But just when this guy, know, just when you think it's gonna be a nice calm day, police officers showed up at your door out of the blue, which is amazing. I'm like, whoop. Um, what did I do here? So hopefully the videos will come through soon. I know TCA exclusive, indeed. My days, this is. Oh my days, Garden Bot is gonna laugh so much because I don't know why, but I have a magnet to attract. Well, not police officers, but I get stopped regularly by my car at 4 o'clock in the morning. But that's another story. Spot you pause boy is epic. She has her and hold on a second. Yes, it is. Look at that. It is iconic. That is very iconic. Oh, in real time. Yeah. Oh, wow. This is some crazy stuff. Wow. Very good. Now, while I send this videos, let me whew, think I'm calmed down now. I think I'm okay. I mean, it's fine. I'm okay. I know I did not do anything, but it's never a good thing when police comes to your door. And I was like, but the thing that are really kind of annoying me a little bit more, and I know this is pickles, but it doesn't even ring the doorbell. He's lucky. I heard the door. But it just knocked at the door. Man, there's a bell right. No, but okay, that's just me. Now we get to play detective with you. Yes, you have to tell them that we want. I know I want everything on this case. I absolutely want everything on this case. And oh my days, this is absolutely hilarious. And I was just thinking when I was talking to the office, I was just thinking I just need to share this with the guys. I have to share this with the stream. I was like, I can't wait. I was actually hoping that I was gonna find something. Damn camera did not find anything. I think it must. Oh, I'm so upset that the camera did not find anything. But it's just. But I have other neighbors that they have cameras, so they might find. But this is crazy. This is absolutely insane. Oh, my phone is buzzing so much. Um, not because of this, but just notifications going out. But oh, I know. Baby's almost asleep. You can sleep, Baba. Oh, right. Let's continue with Judge Boyd, and I'm gonna try to send this by email because it's not sending for some reason. I need this footage. Ring. I need this footage. This footage is mine. I need it. I might even do a little video like police comes to my house edition. Okay.
That's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County.
Okay.
They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You
I
understand?
understand, Your Honor.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything,
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay?
understood.
So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mhm.
My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel. Right, Mr. Beltran, that's not to be heard right now?
All
Okay,
right, and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand?
Understood.
And Ms. Gay, are you on the first-degree will?
yes, I am.
All right.
So the next document is entitled Court Constitutional Notice.
Mhm.
And that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right. The first is new discovery of antitrust violation lies, fraud upon the court, elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the state bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you the state bar of Texas is not prosecuting you. The state bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the state bar of Texas, and they have to pay dues to the state bar of Texas. I think it's $265. It may have gone up. All right. So they're not going to be trying you.
Yes, sir, Your Honor.
All right, the next one is State Bar's virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false State Bar, anything with regards to the State Bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding the selection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell. There are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this law.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases?
No.
All right. Does that address that issue for you?
Yes, ma'am.
All right. Then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, ma'am.
All right. Does that address that issue?
Yes, ma'am.
I think the other issues deal on the second page, deal with the State Bar, and I think the courts address that.
Okay.
The other one is gross advertising negligence of the DA's office.
Okay.
And defendant being sued,
Who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is that something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial. Okay.
Yes, ma'am.
All right. All right. Is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No, no.
All right. Is there anything that you don't understand about the jury trial process?
Mm.
All right. So I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, ma'am.
All right. So if you still want a jury trial, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right. So, counsel, you're still requesting a jury trial? All right. Norma, if you can put them on the jury trial, please. And Ms. Galloway, if you'll confer with the defense on a jury trial date. So they're going to get a jury trial date, okay?
Thank you, ma'am.
Oh, you're welcome.
See, this is why I love Judge Boy. She's so, like, she can diffuse a situation so calmly and so beautifully. She's absolutely amazing. You know, this situation could be a completely different. You know, we've seen with different judges, but she's just out in a very calm manner, and it's just amazing the way that she did. Right now, are you ready for uh the highlight of my day, probably the highlight of my week, seeing the videos of the outside of my house when the detectives are. The first one that we're gonna watch, this seems like a trial. We're gonna watch a ring camera video. Is the one that they are just outside by my car and in the car park of where I live. So it's okay. It doesn't tell where I live, and it's fine. You'd never find a house anyway. So this is it. This is where I live. This is the car park. That's my car down there. This is my car. I don't think if you can see, but that's, hey, Kimbers, Ohio. Good morning. Hello, welcome in. Nice to see you, my friend. Hi. We are just watching some things that happened outside of my house just a couple of minutes ago. Some police came. They wanted some information on something that has happened in my area, which was a lot of fun. So they're there. That's like them down there by the car. I don't know if you can hear the audio or if they say anything. So that's the two. They were just around. Because that's my neighbors there where they just passed. I don't know. Oh yeah, you can. There is just my neighbors, and my door is here. So I don't know what happened. They just asked me for footage of my camera because we have this camera looking the car park exactly for this type of situations for security, and Garden bought parks his van there. So yeah, it's crazy. So this is the one they are just outside. They go around because that's the way around, but then they come back to come to my house. So that's the first one. And then I think this is the second one when they come and find that there's a house here. So this is the guy. This is. Can I zoom in? He is kind of cute. I'm not gonna lie. Ooh, I can download it.
This is 7. Aye.
See, that's my door. See, he knocked. Why do you knock? There is a camera right there, a ring bell camera. Why? But anyway, that he's kind of cute. I'm sorry. I know the perspective on this is not the greatest on the ring camera, but he is kind of cute. I did find him cute, but don't tell Garden Bot. So that was just that the second, and then this one I think is when I went to grab my phone or something. It's a bit longer. Let me share this one instead. She doesn't look too bad either.
But I don't know whether they've already got their footage or not, which is why it's not.
Yeah, that's what, because the door is open. So I went to grab my phone at this point because I did not have my phone or Anya with me. She was just crying in the bassinet. Oh yeah, look at the bottom when I take. Oh, hang on. Let me take this. So at the bottom when I play, it has the date and everything like it has in the trials. Sorry, this is my first time using a ring camera for this kind of purposes, to show other people something that has happened. So do not look at the mess. That's my bike. Then that's the shit that Garden Bot built. This like thing that you see here, this kind of like porch area, if you want to call it, that was Garden Bot that built that. It did not came with a house. Garden Bot built that. The fence got put up because we were able to come through there. But yeah. Oh, good morning, William. Nice to see you. I don't think I have said good morning to you, but good morning, my friend. So yeah, so that's what happened. That was the videos. Did not record the conversation I had with them for some reason, but it was just because they were asking for footage for an incident on the 6th of June, and yeah, and now this was the little bits that happened outside my house, which was crazy. Yeah. So I know the lady's cute from the side. I did say that, Hannah, but you can have. She did had a nice voice. She did not speak much as him. I think it might be the lead investigator. Let's zoom in. Oh no, we cannot zoom in. Oh, man, but she might be. It might be the lead investigator because I can't even zoom in. What? This is not good. Oh, do I have? Is magnifier working? The magnifier is not working. Oh, you're tracking your parcel. What did you order now? Yeah, we are just checking out now, but we can laugh about it. It's a gorgeous day though, over here in UK yet again. But I have to give them a code because of, oh yes, you tracked that parcel down. I was the same tracking when my phone was coming. Absolutely. Oh, computer things. Sorry, I need to be excited, but in a low voice tone because Anya is sleeping finally, and I don't. If I turn off the white noise thing, she wakes up. So I'm having the white noise from the phone on at all times, so like that she can sleep. Whew. But oh, definitely, Kimba's was the best purchase that we did. Not that the area that we live is a bad area, but because better safe than sorry, because Garden Bot, he has a lot of tools for, so oh, you need to change your 4 stops away, that's close. So in this shed, Garden Bot keeps his tools, right? And then outside, on the outside where we park the car, so here where we park this is my car, and then the van is parked behind, or vice versa. It depends who goes first in the morning, and his van stays here, even though it's not about the neighborhood. The camera allows us to see into the car park, and anything that happens around this area, it's captivated by the camera, it's captured by the camera, and then if something happens, we can deal with it. So it's a security thing. Sadly, these days, you gotta do it. It's no matter where you are, you don't have 100% security, sadly. So that's why we have the cameras up. But it was not scary. I was just so excited about it because I can share with you guys, and then I have the proof. I have the camera. I have the ring cameras to show. Like, yes, this is gonna show on the cameras. I can show everybody. And the thing is, I can talk about it because there was nothing that I could help them with. They say they might be back, but we'll see. The only footage I had was from that day, but in the morning. So that's why they say they might come back to get that footage, but they were interested in another the time frame. But yeah, it was excited. This is yeah. Um it was crazy, it was fun. mm, you know what we are definitely, definitely an addict for true crime because I get excited with stuff like this, right? So now moving along, um we have one more clip from Josh, and then we can go to Colin's hearing. Then we might hang out a bit. We'll see how everyone is feeling and how am I feeling and how baby is feeling as well, and then we'll see. So it's one from Jeff from Middleton, the judge. Don't know anything about it, but let's watch. It was a recommendation from Josh, so it's good. We know that. They found out, yes.
Your Honor, Mr. Gabriel is willing to come in and speak with the court. We would ask that it be off the live stream. It can still be an open courtroom, but we would ask that it not be streamed.
All right, thank you.
Thank you.
Oh, yeah, you can see.
Lori, did you get that test result?
No, did you?
I didn't either. I didn't worry about it.
You didn't hear about it? Who told you?
Just the corrections of the sheet. Oh,
Well, I just got that one there.
Is Miss Welsh here? Okay. You heard the results.
I
She
only
was
heard
positive
of
for
the-
everything. Lori,
Lori,
your client was positive for methamphetamine, fentanyl, cocaine, and perhaps something else. Marijuana.
does Autumn have a test result or something?
No, one of the issues is just an instant test, but her report back to the court was the defendant was positive for
So it's meth,
methamphetamine,
fentanyl.
marijuana, fentanyl.
Does it show levels or just?
No, it doesn't. That's,
Just what she's.
it's an instant test, so the levels would have been high because it's not a very discriminatory test.
Well, I think from watching her come in. Did you hear wrong? Yeah, I heard something.
I spoke with somebody from Georgia school.
Right.
And
Yeah.
if they can get her a bed and the inpatient rehab,
That'd be great.
get her to stay.
But it would be like a condition.
Yeah. Okay.
So I don't know if you've talked to her since yesterday. Maybe. I don't think.
That place in yes, it's a pretty soft judge.
I don't think we can take her out of Michigan now.
Oh, yeah. Yeah, but then it's there to support.
I'm not sure who our go-to person is at the jail. We had Lisa all those.
Guys, sorry, hold on everything. But I was just Googling because, my mind is going crazy of what happened, right? In my area for the police to be investigating. And I did. I searched, I put my fingers to work, and I am not going to share because it does say the area where I live, and but I'm going to read to you. 2 boys, age 16, and a girl, age 15, have been charged with attempted red rum. And then it reads, at around 6:10 p.m. on Friday the 6th, police were alerted by an ambulance to serve to an injured teenage boy, and then says the address, which it is where I live. So let's not say that. So they say where the address is. And then says emergencies services attended the scene where the boy, age 15, had sustained serious injuries consistent with being caused by a bladed article. So it was a pokey device thing. And then they've been charged with attempted red rum, and they are remaining in police custody, so no bond, and are scheduled to appear before a youth court sitting in the South Side on Monday. Oh my days. This is nuts. This is crazy. Yeah, so no, police is saying with proceedings now active, we ask people to refrain from speculating about the incident both online and in the community. Too bad. You came to a content creator. Yeah, no, that's not. I'm gonna speculate all I want. But also to remind everyone that those who are under 18 and charged with a crime have a not. There can be anonymous unless charged as an adult. Wow. Oh. So the victim is in the hospital being treated, but yes, I can find when this is the court. Well, they've already been to court, but whenever that happens again, I definitely can. I'm gonna keep an eye on this case now. Oh my days. This is absolutely insane. Oh, I wish I could share like they have the article, and they have like a thing, a news article, but it says the where it says where I live. This is, oh wow. This is absolutely insane. Apparently it was in the park. I live just by this park. I literally, oh my dear days. Oh. Yeah, because just outside my house, I don't have the videos up anymore, but just outside of where those, the videos we saw, there was all those trees. That's the park. That is literally, um, wow. Uh, oh, Hannah, do not talk about the heat. This heat is not to be talked about. Um, oh, this is absolutely insane. Sorry. Can you start gathering the evidence for conviction? I probably can. Wow. I might go to the park tonight and do a recording of the park because I can show, because it shows exactly where it happened, and I know exactly where is this. We go to this park very often. Um, I know. Now I know how you feel, Stephanie. I absolutely know how you feel. Absolutely. This is crazy. Oh, right. I know it's freaking like, oh my days. Oh, this is what happened. I need to keep on top of it. Anyway, let's carry on watching this whole situation. Like, apparently
Years, and
good.
I'm
I
not,
don't think there's.
Because
any-
baby's
I'm
awake.
not sure we have the same
You know,
levels.
when it is, when I ask clients, when I go over there, they're just like, nothing.
They have nothing.
They have nothing.
Bang, light a fire under somebody.
I thought there was a lady that was upstairs in the same office as Melissa and Mandy. And she was like the jail liaison.
I'm not sure. I'm gonna reach out to somebody.
The last two people that we requested whatever for, they wanted to argue about insurance. And I'm like, okay, so we're in crisis and they're locked up. What would you like me to do with their insurance? Yeah. The rules, Joe.
Yes. I've got a whole bunch of your other attorneys here this morning, so before we leave, let's all, I'll maybe talk about all the stuff. Good. I don't know what we're waiting for.
We're waiting for Mr. Gabriel. I'm
Is
not
there
sure.
another hearing in a different court?
I'm sorry.
I thought it was done.
He is, I guess I was hoping the court would address.
No, I'm not doing it in chambers and I'm doing it on a live feed. If he doesn't wish to be here, we'll make a record. I'd like him to be here. He had a position he wanted to state. I never got a chance to explain my position. So no, if he doesn't wish to be here, then I'm gonna proceed accordingly.
Kind of, we go take care. As far as Mr. Fuller's case, is there a drug test?
Well, I called. We'll address that when everybody gets here. We can't do an instant drug test because we don't have a male certified to do it. We only have Autumn. So I'm going to send him to the day reporting center directly from here. There's a condition of your bond that you test on demand of any police or court officer. The prosecutor's asking for a drug test. I would prefer to have done an instant one. We did one yesterday, which we're going to deal with in a minute, but I don't have the ability to do that. So when we finish here, you're going to go directly to the day reporting center and test, and then we'll deal with the results of your test either when we get them or at the time of the prelim, which is set for next Tuesday at 1 o'clock.
Yes, sir.
All right, good morning. Mr. Gabriel is here, and we're going to proceed. This is in the matter of Peoples versus Karan Duvar Fuller.
Your Honor, this is on the record, the light.
Oh, yeah, good, thank you. Thank you, Deborah. Laura came in to check. This is in the matter of People versus Karan Duvar Fuller. Mr. Fuller is here with his lawyer, Mr. Ross Truckee. Also present is Assistant Prosecuting Attorney Gary Gabry and Prosecuting Attorney Deborah Davis. Mr. Fuller was charged in April with being a felon in possession of ammunition. I believe that alleges he had 2 shotgun shells. Anyway, because he is a felon, he's not allowed to possess ammunition, and the matter was charged as a felony. He is on bond on 3 other felony cases, which are all bound over to the circuit court. And he was charged with this. Judge Pattison set the bond at $10,000 cash or surety with certain conditions, including supervision of the Community Corrections Office and drug testing. The defendant was here on, I believe, May 13th for a pre-exam conference with Mr. Truckee and indicated at that time he wished to have a preliminary examination. So the preliminary examination was set for May 20th. And I'm going to represent what I was told so anybody can correct if it's different. At any rate, the defendant didn't show up on May 20th. Police officers were here prepared to testify, much to the consternation of all of us, including me. So I issued a bench warrant and set bond at no bond. I wanted to see you personally. Then I went on a trip. I came back on Tuesday, May 27th. I believe it was, this occurred the following day. I may have my days mixed up. I thought it was Wednesday, the 28th. At any rate, there was a warrant out for Mr. Fuller's arrest for failing to appear at that hearing. He called the court that day after the 20th and said, in the afternoon of the 20th, so I missed my court date. And they said, well, there's a warrant for your arrest. Between the 13th and the 20th, Mr. Fuller came into the court and paid some payments on a payment plan that he was on for some other cases. So between the 13th Tuesday and 20th, they didn't show up. He was actually in the courthouse and paid on some fine. So he didn't show up on the 20th. Then he presented himself at the court. Now, Mr. Truckee or Mr. Fuller, you can fill in the details here. My understanding is Mr. Truckee told him to turn himself in at the jail. Rather than meet him here at the courthouse, Mr. Truckee was here that morning. He told him to turn himself in at the jail. My understanding is, and correct me again if I'm wrong, he went to the jail and sat there for about 45 minutes, but they said they were too busy to book you in. Is that true?
Yes, sir, Your Honor. So
you came from the jail to here. So I'm in the middle of a busy morning with a bunch of other stuff going on, and here you are. So you walked, Mr. Truckee walked out the door, you walked in the door. So he was gone. We tried to call him, but he was already on his way to Three Rivers. So here you are. I canceled your bond. It was my bench warrant. And there's a statute that nobody likes, but it's MCR 6.105. It's actually a court rule. If a defendant wanted on a bench warrant or arrest warrant voluntarily presents himself to the court on that warrant within 1 year, the court must either recall the warrant and schedule the case for a future appearance. It is presumed that the defendant is not a flight risk when the court sets a bond order or other conditions of release at arraignment. So that's what I did. There was another option. You can arraign the defendant if the court is available to do so within 2 hours of the defendant presenting himself. So he'd been to the court between the dates. He called the court the date he missed. He went to the jail to turn himself in. They wouldn't accept him. So I went with option 2 of the court rule, which allows him to be presumed to not be a flight risk and appear, which he did. Mr. Truckee was scheduled to be here this morning. He was late. He did call and said he was running late, but he's here. I didn't give him a PR bond. I simply recalled the warrant and reinstated the $10,000 cash or surety bond that was in effect. So it's like, okay, no counsel was here. Mr. Stickley wasn't available. Mr. Truckee had left. I didn't give notice to the prosecutor. I simply scheduled the matter for this morning. And then went on back about my business because I had other stuff to catch up from being on vacation. So some point later that morning, Mr. Gabriel came into my chambers. I was in there signing some orders and I said, hey, good morning. I got something I'd like to talk to you about. I had a misdemeanor complaint that was handled by their intern that I wanted to check with him on. And he said, I have more important things to talk about than that. And he said, why in the hell would you give Karan Fuller a PR bond? And I didn't have an instant response, but I didn't give him a PR bond. I just recalled the bench warrant. And then I said, well, I guess I'm sorry I didn't give you notice of the proceeding, but he just showed up and I cited the court rule. So I set it for today. So Mr. Gabriel was quite upset. He got up and either said, this is disgusting or you're disgusting. And he walked out of my office. And this was ex parte. Nobody else was in there but us. And so I left sitting there thinking either me, now maybe the statute is disgusting or court rule that there's a presumption if they turn themselves in, that they're not a flight risk. If I had done that when I was assistant prosecutor to Judge McManus, Bob Karras would have fired me that morning. When did it become a thing that the assistant prosecutor could come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. I don't believe you do it to Judge Stutzman. I don't believe you do it to one of the judges in Kalamazoo. I followed the law. I had an understanding of the facts. I followed the court rule. I set the matter for hearing. He's here today. The offense he was released on was possession of 2 shotgun shells. I don't have the discretion to cancel this bond because Gary Gabriel is mad at him. And I didn't deserve what you came in and said to me. In my career as judge, you've been the most disrespectful attorney to me, bar none. An attorney came to me after a hearing and said, how long do I have to be a lawyer before I can be as much of an asshole as Gary Gabriel was to you? I don't deserve that. And I didn't deserve this. I followed the law. I had a better understanding of the facts than you did. I had a better understanding of the law than you did. And he's here now. Make a motion to cancel his bond in circuit court if you're that upset about it. I'm going to send him for a drug test here before we're done this morning. This violates the canons of professional responsibility. You have an obligation to treat the court with respect and your other lawyers with respect. And I understand that you were upset, but you left before I even got a chance to explain myself. So that isn't a thing. The assistant prosecutor can't go into the judge's office and say, your ruling sucks. That's not how it works. So I didn't deserve it. I don't deserve it. And I believe I was right. And he's here now. We're going to have a drug test. You have your right for a preliminary examination, which will be next Tuesday at 1 o'clock. And we'll proceed accordingly. So what I expect is you to apologize. I understand that you lost your temper and you're upset about it. And that's to be understood. Nobody liked Court Rule 6.105. It was very controversial with the judges. You either had to let them go or drop everything you're doing and arraign them within 2 hours. And As I said, he had turned himself in at the jail and they wouldn't take it. So I set it for this. So that's all I have to say on the matter. Ms. Davis?
Thank you, Your Honor. First, I would like to say that we were not aware of Mr. Fuller attempting to turn himself into the jail. But that's the first I've heard of it is today. We'll certainly be following up with that. Our belief is that the bench warrant arraignment is a critical stage and that he should have had an attorney. We have made it clear at the last hearing when the request was made that we felt that Mr. Fuller was a continuing risk. He was involved with felonies. He's not new to the system. He knows how this works. He knows where he's supposed to be and when he's supposed to be there. His pattern of behavior towards law enforcement is extremely dangerous, with fleeing and eluding and resisting and obstructing. And in order to protect society and give our law enforcement the support that they deserve too, we were asking that his bond be canceled and that he be remanded. The concern is now that he continues to be around people who use substances. So his history and not showing up, I'm thankful that the court is going to have a test done.
Well, let's assume that all that is true. What gives him the right to come into my office and express his disgust for my ruling?
Your Honor, I don't believe that it's not appropriate. I get that. We are in a very difficult situation in our office in light of everything that has happened in the last year and a half. So it's been very difficult. It's been very stressful. And I think overall, Mr. Gavery has the same philosophy that I do as far as holding people accountable and taking action so that people know that if they do get in trouble, we're going to hold them accountable and not just allow people to waltz in as when it's convenient for them. It's not convenient for any of us, and we do our best to have somebody available at all times so that if there is an emergency hearing, the court can call down and we will get somebody here. So what happened, the way it was described to me was different than what
well, there's two sides to every story.
Correct, and there's perceptions. So I know that Mr. Gavery apologizes for the.
I don't want to hear it from you. I want to hear it from him.
Well, I understand it. We'll give him a chance to speak in just a moment, but from the beginning, it's my understanding that the comment was made as far as the whole process, because we feel like we're doing our best to charge, hold people accountable, and show up whenever we can.
Well, we've got a case where he's charged with possessing 2 shotgun shells. Move to cancel his bond in circuit court. If you could, I don't want to hang my nail on canceling a bond for someone who was here in between, called the court, went to jail, and the law doesn't require that I give notice to the prosecutor. I had one of these yesterday. I have one almost once a week. Somebody shows up. So he's here. You're right. He keeps doing stuff. Or try one of the cases. He's got 3 cases bound over to circuit court. He got charged with a crime, got arrested again, no motion to cancel his bond in circuit court. We set his bond at $10,000 cash or surety with conditions. So it isn't like we're just saying, please don't do this. But it would have been an abuse of my discretion to cancel his bond for not showing up on a case where he possessed 2 shotgun shells. So I set it for this hearing, and he's here, and we're going to drug test him, and you can have a prelim next week.
Thank you, Ron.
Mr. Gabriel.
First of all, let me say without any equivocation that I apologize for losing my temper, for addressing you more as someone that I have known for my entire career in criminal justice, someone who, with me, taught a number of even elected prosecutors right now how to try a case, how to be a prosecutor, what the ethics are, involved in prosecution. In my 45 plus years, I have never been held in contempt. I have never disrespected the court when on the record. I have always prided myself on not only doing the right thing as a prosecutor, but also protecting the community's interests and law enforcement's resources. The comment that I made to you would never, Your Honor, and I think you know this because you and I know each other, our wives know each other, we've spent time on Mackinac, would never indicate my disgust for you as a human being. I have the utmost respect for your career. I do, however, differ with some of your handling of matters, one of which is your live stream. And you are aware that I took an opinion about that the last time I was here. I still come to court when I can. I was brought in here to handle circuit court with the idea that this office might be able to get back where it should be before the last prosecutor dismantled things with his blatant accusations against my present boss. That's why I'm back here. Because I believe in this prosecutor. I believe she's the first one you've had in a while that wants to do the right thing. And the right thing, just like it was the first time I was here for a while, was to hold the people that are putting a huge burden on the citizens in this community, to hold them accountable. My anger and my disrespect was directed towards a feeling that I have that this court expects a lot of its prosecutors to be here, to just wait, to address things that, as I just conveyed to the chief judge, one of the few counties I've ever been in as a prosecutor or a defense attorney where prosecutors appear routinely at sentencings. It just doesn't happen anywhere else. Why? Because they're busy. Well, we're busy. We have 3 people. One of them is the elected prosecutor, the newly elected prosecutor who has her hands full, just trying to correct the errors of the past year. That leaves me handling circuit court and helping out in district court, while Mr. Robert is helping out in district court and also spending a lot of time in Three Rivers. So yes, there is a lot of pressure on this office. Did that enter into my feelings of disrespect for how this system operates? Yes, it did. It was never directed towards you, Judge Middleton. There are times when I lapse and I have to think to myself to say Judge Middleton, because we've known each other a long time. I will, if I can, be honest now, not that I haven't been up until now. You will recall that while at that prelim, I came in here and I advised the court right away that I had been working and trying to get Mr. Truckee to let me know whether Mr. Fuller was going to waive or not waive, that I had talked to Mr. Truckee about what would happen if I'm going to have to bring officers to come in and sit as what you call kind of so what case. Well, they came and they waited and they waited and we waited. I looked at this young man's record, this 34-year-old man, and I saw bench warrants just like this on the Walmart case and the stolen car case, where he was supposed to be here. And ups, it got adjourned, come back. I think Rhonda Ives, nope, no bench warrants issued. In this situation, what happened from our perspective that day was I appeared at the prelim. I respectfully laid out why I thought it was appropriate that his bond be canceled, that a bench warrant be issued so that he could be brought before the court. And I knew he was going to get another bond, or at least we might find out, A, is he around? People assumed he was. I don't assume anything. All I know is he was supposed to be here. You did a bench warrant. I checked when you were gone because Mr. Robert pointed out the ROA was confusing, that it sounded like he was to be something about arrest, but the warrant was there. So I talked to Judge Pattison. We went to the district court. We clarified the day before he walked into court that the bench warrant was valid. Mr. Truckee had told him to go to the jail. And I knew nothing about him coming in here. Certainly knew nothing about him going to the jail. I knew nothing about him coming into the court when there was a warrant, and nobody in security notified us. What I was notified of was when my prosecutor walked in that morning and said, I just saw Karan Fuller riding a bike or something down the street. What's going on? So I go up to security and they tell me, oh, he came in and Judge Middleton let him go. That upset me. It upset me because I thought that because of the respect that I've always shown this court, my willingness to try to be here to do what I can to help out, that I would have been notified of something when I'm sitting in my office looking at my cases. I want to know why he wasn't here. That's usually what happens in circuit. They get arrested. Why were you here? Well, my mother was sick. Okay, we'll reinstate the bond. Something to impress upon people that the court means business. And that's all I ask as a prosecutor, that the message that gets sent through this live stream, through our appearances in court, means something. Not comments like on the record, well, it's not the crime of the century. Or it's a pain in my neck when this happens. Pardon me?
Yeah, he is a pain in the neck.
But he's more than that, Your Honor. He shows disrespect to you, too. Your statement that you made about, well, it's more trouble to book you in and then book you out.
That's true.
It is. It is. But that's the system that's in place,
All right,
isn't
listen,
it?
I agree with everything you said.
And let me finish, and then I'll take my admonition. I do not recall that you ever indicated, or that I indicated a PR bond. I didn't know what happened. All I knew is you let him, they told me that you let him out. I didn't hear the court rule cited whatsoever. That, I think, would have been the thing that we might have done on the record had he been brought in and Mr. Truckee held here or held in the jail and held in lockup until Mr. Truckee got back, because I'm interested to know what kind of contact, if any, he even had with his attorney after he walked out of here. Those are the kinds of issues that go into my decision on whether I'm not going to use additional resources to just simply file a motion in front of Judge Stutzman and bring Ms. Ives in and bring everybody else in because of the multiple attorneys that get involved here. So there are a lot of things that I like to discuss. And I think if you talk to the chief judge, you'll hear that we talk about ways to try to improve the system, to try to make it more efficient, to try to make it work with just 3 of us. So yes, I was angry. Yes, I regret my comments to you, and I regret losing my temper. I don't want to be seen as that way, but I have been doing this for pretty close to 50 years. And I've seen it all. And I've been a judge dealing with parolees going back in front of me on the pro board. I know what it is to disrespect someone, and I feel bad that I did that. And I feel bad that I did it to somebody that I, in the past, considered a friend. I hope you will accept my apology for that and recognize that the frustration that I have is not because I'm lazy. It's not because we don't want to be bothered. It's because we want to try to make the system work for the people in this county, the people that are paying a lot of money. My last comment that I wrote down when you were talking is what you said about the court rule. And I will say, I don't have that memorized. I haven't really experienced that before. Nobody's ever cited it to me. The way it's been handled is what I just outlined. Come in, hear your story. Why didn't you do? ask the defense attorney, what kind of contact did you have? Usually there's the admonition. I'm going to let you out. You're going to be in touch with your attorney. You're going to be on time, not 10 minutes late for court, like this morning.
We went through that.
Okay. And is he, not presumed to be a flight risk? Let's not forget that this case, in which he faces life or any term of years because of his past record, is right on the heels of the case in which he led law enforcement through this little town in a high-speed chase while he allegedly was carrying meth and a gun. So this man is bordering on heading into a lot more serious. And it seems to me, and again, I'm not going to go into comments that you and I had off the record about your past dealings and family's dealings with Mr. Fuller. But yes, I was upset because I have a perception that this is not being treated seriously. And for that, I apologize.
All right, your apology is accepted.
Thank you.
Within the week, Judge Pattis and I had a discussion just before I went on my trip about what an asset you were to the prosecutor's office. You can try a case in circuit court. You're willing to do misdemeanor pretrials. You show up at sentencing and do appropriate, thoughtful comments. And Judge Pattis and I both believe, I'm sure Judge Stutzman too, that you're an asset to your office. The office wouldn't function without you being there. You and I go back 45 years, which is in part why you thought you could come in there and unload your anger on me. Yes, we taught a generation of young prosecutors how to be a prosecutor, including our current attorney general. But this case isn't the one to hang it on. Now, we'll have a drug test, and I have my suspicions of how that's going to turn out. And we'll have a prelim if necessary on Friday. When all the cases are in circuit court, perhaps you can file a motion to cancel this bond. But that's up to Judge Stutzman, and he's got multiple counsel. I think there was an effort to try to do everything together. Anyway,
Your Honor.
I regret that this whole thing happened. I discussed it with the chief judge when he got back, said, how should I deal with this? I don't think it deserves a grievance. All I wanted was an apology, and I got one. And the case will move forward, and the defendant is here as under the court rule. And I said, nobody liked that court rule. It was probably the least popular in the whole criminal justice reform package, but I'm bound to follow the law. Yes?
You had mentioned prelim on Friday.
Excuse me, I'm sorry.
Okay, just want to make sure.
No, Tuesday, I don't want to make any further confusion. Tuesday, June 17th, 1 o'clock, Mr. Fuller, you're to be there at that time. I want you to go directly from me.
I'm sorry, June 17th or the 10th?
Boy, I'm all screwed up. June 10th, next Tuesday,
All be on the same
June 10th, not the day we've been using for the others. I want you to go to the day reporting center right now, and we'll do an 11 panel test. We'll figure out who's going to pay for it, but it'll be paid for.
Yes, sir.
Then it may take a few days to deal with that. We'll deal with the results of that at your prelim next Tuesday. All right, you're free to go. We'll let the day reporting center know that you're coming. Or will you call them and tell them Mr. Fuller's going to stop there for a 11 panel urine test?
Thank you, Your Honor.
Thank you, Your Honor.
This matter is completed. Let's bring Ms. Welch in and deal with that matter.
Security has concerns that she is detoxing. I did meet with her. They believe she's in her beginning stages, so she is a little fidgety.
Well, let's see.
Anxious. So.
Okay, so sorry guys, is it over now? So did it finish? I think yes, it did finish. Sorry about that. Baby's was it's very, very fussy. Jed is on with her at the moment, so if you hear a baby crying, it's fine. I'm not ignoring. Jed, the garden bot, is with her at the moment. But I only heard part of that once, but thank you very much, George. I only heard parts of it because I was feeding the baby and doing all baby things. But that sounded very spicy. I'm gonna have to go and rewatch later again, absolutely, to have a look at what was going on because it does sound very spicy. Now, what we're gonna watch next is the Colin Gray hearing. We've done the Rodney Hinton hearing. As a summary for that hearing, was a nothing burger. Literally nothing happened on that hearing. Was just to schedule a couple stuff that they did, and they did absolutely nothing on that hearing. So it was literally what 5 minutes, not even that. Was just like an in and out type situation. But this hearing, the Colin Gray one, if you're not aware, Colin Gray is the father of Colt Gray, that was is the accused high school pupil in Appalachia School in Georgia that happened in the beginning of September 2024. They are about to go to trial soonish, I think. So now Colin Gray and his attorneys have filed a motion because they want to move the where the court is, where the trial is supposed to be, to a new place. So that's what the hearing is about. Oh, you are from there, Josh? Oh my, Josh, sorry, that's crazy. Wow. Well, so that must be hitting a bit close to home to you. But yeah, so this is, I know it's crazy. I think we're having hearings of where people are from today. I had the situation happening for literally at my house. Stephanie had something as well. Josh has this one. Hey, we all kind of popular. But anyway, let's start the hearing. It was a very sad situation. I am not obsessed with this trial, with this case, but I am very interested because I started doing this YouTube social media thing around this case, around this one as well. So yeah, I'm very invested in it. So let's watch. Hopefully the sound will be good. Let's see, where does it start? Oh, right around there.
I sent you an email about serious pending charges in our division.
You did. I went out yesterday, but I'll work on that.
I just couldn't remember if I thought to do it or actually did it, so.
You did it actually.
All right. All right, Mr. Gray is present. So good morning. We have motions today. I understand we have demurs.
Yes, Your Honor.
What else are y'all presenting today?
Judge, we just have a special demur as well as a general demur for today.
Okay, no other motions?
Not today, Judge.
Okay.
I think we still have a deadline per your scheduling order when some of the other motions should be filed.
Yes, sir.
I know discovery is still in and coming. We got some more this week, so we're just kind of putting together our motions as the discovery comes in.
All right.
And if you file a motion to revisit the change of venue, to know if that was, your claim was already got today, or?
We can certainly, Judge. It's not going to be the 3 or 4 minute arguments. Sure. I'm happy to entertain that today. Sure. All right. Defense can go ahead with their demurs.
Jimmy, do we do the special one first? Sure. Sorry, Judge.
It's all right.
Judge, we're going to, just for the state's information, I'm going to do the general one first, and then Mr. Barry's going to do the special.
Okay.
I don't know if you want to respond after. It's probably easier for the court, but I'll leave that to the court.
Yeah, we'll do the general first, and then we'll hit the special. The state can respond as we go.
And I'll keep it.
Just need the indictment.
I'll try and keep it simple, Judge, or straightforward. I know we're all pretty familiar with the facts of this case and what a general demur is. The court's well aware. We are demurring as to counts 1 through 29 as being void for vagueness as applied and for failing to allege that the defendant's actions were the proximate cause of the deaths that have been charged in this case. as well as a reasonably foreseeable consequence of the defendant's actions in this case as well. I'll talk mostly about the vagueness. I think the proximate cause issue also bleeds over to the special demur. And so I know my co-counsel is going to touch much more extensively on proximate cause. So rather than do the same argument twice, I'm going to defer and let him make that argument as to proximate cause, as well as the prong of reasonably foreseeable consequences. So in terms of vagueness, Judge, we're moving the court to dismiss counts 1 through 29 of the indictment because it rests on irreparably vague statutes stemming from the 14th Amendment's due process clause. The void for vagueness doctrine ensures that the people's representatives make certain conduct a crime. And as only the legislature may do, they must provide enough detail so that people of ordinary intelligence don't need to guess at what it is the state commands or forbids.
I'm sorry, is there a claim that the various statutes are unconstitutional?
Well, we think they're unconstitutional for vagueness, Your Honor.
Okay.
Based on, so for example, in the cruelty in the second, it references cruel and excessive physical or mental pain. That would be one of the clauses we believe is vague as applied in this case. As to the reckless conduct, the involuntary manslaughter, the involuntary is based on reckless conduct, and the murder in the second degree is based on the cruelty to second degree. So the vagueness flows from the cruelty to the second up into the murder to the second as well. And then we believe that by not clearly defining the conduct, by leaving the definition of this conduct to, for example, prosecutors or judges to define, or more likely a jury to define, it creates a situation where the statute itself is unconstitutional for that vagueness. In federal vagueness cases, courts construe the statutory language in context, determining whether the statute itself or prior construction provides sufficient notice to the defendant. Reviewing Georgia law, this appears to be a case of the way this case is charged in regards to the cruelty of the second, meaning our client is charged by either doing or not doing certain actions that led a third party to do the action which makes up the basis of the cruelty in the second. By interjecting that third party, not only does that create issues with proximate cause, as my co-counsel will further elaborate on, but it also leaves not only the actions or the actions that define the crime vague, but it doesn't put an ordinary citizen on notice of what the prohibited conduct would be. And in terms of looking at case law for the Court of Appeals or for other courts or Your Honor to determine definitions of prior actions that have led to this charge, the way it's charged in this case by that extra third party causing the action that makes up the cruelty in the second, there's very little case law for the court to look at. And there's very little case law for my client to be informed on what the prohibited action is. Wholly separate from any federal claims, defendant also demurs to vagueness on both separation of powers and privileges or immunities grounds. In Georgia, all crimes are defined by the legislature. The power to define crimes and prescribed punishment has long been held to be an exclusively legislative power. And in criminal law, the legislation can only exercise that power constitutionally if it defines the crime with clarity and precision. When the legislature adopts a statute that renders an essential element subject to the jury's unfettered discretion, such in this case with the definition of cruel and excessive physical or mental, then we lack the clarity necessary to put the defendant on notice as to what it is the prescribed conduct is. By leaving that definition to the jury, then in each case, the jury itself construes the law for itself. What that means is that there's no chance that a final construction of the law that would occur and the limits and duty imposed remain unsettled until after the fact. Here, by constituting or by making what constitutes cruel or excessive mental or physical pain depends solely on the jury's discretion, the cruelty to children in the second statute is abdicating the legislative power to the judicial branch. And instead of knowing with certainty and definiteness what conduct is prohibited, the defendant is left at the dark, subject ex post facto to the random determination of the jury. Judge, we feel the same argument applies also to reckless conduct because it's also a statute that depends upon the determination of a jury after the fact as to what conduct constitutes a gross deviation. So it's the same argument in terms of abdicating the power of what the prescribed conduct is and taking that away from the legislator and bestowing it upon the judicial branch to determine. For those reasons, Judge, and I will just make for the record, we also believe that there's an issue with proximate cause and that my client's actions as this indictment has been charged were not only the proximate cause of the death charge, but also a reasonably foreseeable consequence. But as I said, I'll let Mr. Berry address that more fully in his presentation. Thank you, Your Honor.
Thank you. Ms. Brooks? I assume Ms. Brooks.
Thank you, ma'am.
Your Honor, I have our cases on a job that I for the defense of the court. And I have a quick clarifying question. The actual general demurrer motion that was filed by defense does not allege anything about unconstitutionality, and it alleges just, the general demurrer that a crime was not alleged. So are they abandoning that allegation?
Judge, we won't abandon it, but we'll just leave it as it's been addressed in the motion for the court's determination.
Well, I'll address the general demurrer first, Your Honor, and then Ms. Daniels pointing up some cases on constitutionality.
You're going to do the general or the specific? You argued the specific.
I argued the general. And Mr.
I'm sorry, I thought I heard you say you.
Specific.
I was a little confused. Okay.
No problem, Judge.
Go ahead.
So essentially, Your Honor, pursuant to Kimbrough versus State, which is 300 Georgia 878, a Supreme Court of Georgia case from 2017, to prevail on a general demurrer, an accused must be able to admit each and every fact alleged in the indictment and still be innocent of any crime. An indictment is sufficient to withstand a general demurrer if the admission of the facts alleged would lead necessarily to the conclusion that the accused is guilty of a crime. So ultimately, if the defendant's actions can rise to the level of criminal negligence, then the indictment is good against a general demurrer. And I think Kane versus State is a very informative case on this, and that's 287 Georgia Appellate Courts 45, a 2007 case. The defendant there was charged with cruelty to children in the second degree based on allegations that with criminal negligence, she had caused the children cruel and excessive physical and mental pain and suffering, to wit, a drowning death, by failing to reasonably supervise and reasonably watch said children. So there, the defense counsel argued the allegations of the indictment were insufficient to charge the defendant with a crime because failure to supervise or reasonably watch one's children does not amount to criminal negligence. The Court of Appeals held that the indictment was sufficient and found that while the failure to reasonably supervise one's child may not in itself constitute negligence, such dereliction certainly may rise to the level depending on the circumstances. And that is what we have here. The indictment is not subject to general demurrer because the conduct can rise to the level of criminal negligence. And each of the counts are based on criminal negligence. So the argument for each count is generally the same, and that's pursuant to Johnson versus State, which is 341 Georgia Appellate Courts 425, a 2017 case that stands for the proposition that reckless conduct and cruelty to children in the second degree are crimes involving criminal negligence. So while allowing a child access to a firearm and ammunition may not in itself be negligent, such recklessness may be negligent depending on the specific facts presented at trial. And in fact, the wording of our indictment specifically requires that defendant's conduct be reckless by alleging that defendant consciously disregarded a substantial and unjustifiable risk that his act of allowing his son access to a firearm with sufficient warning that his son was capable of harming others. So ultimately, if the defendant has sufficient warning that his son was dangerous, then he should have taken his AR-15 style rifle away from him. And not doing so before his son shot and killed multiple people is criminally negligent. But whether or not the state has sufficient evidence is not the question before the court today. That's pursuant to Putnam versus State 257, Georgia Appellate Courts 902, which states that whether or not an act is criminally negligent is ultimately a question for the jury. The indictment adequately alleges a crime and it's up for the jury to decide whether or not the state can prove that the defendant is guilty beyond a reasonable doubt. There aren't any cases, obviously, with this specific set of facts in Georgia, but the appellate courts have found sufficient evidence for criminal negligence in circumstances analogous to this case. Other cases where children were allowed access to dangerous instruments or hazards. So while these cases are not based on general demurrers, one of them is, but most are not, what these cases show is that if properly alleged, an indictment would be good or would have been good against a general demurrer. So you have Turnip Seed versus State, which is 186 Georgia Appellate Courts 278, a 1988 case. And that case affirmed the conviction for involuntary manslaughter in the commission of reckless conduct. Even though at the time of the pit bull attack on the child, there was no state law specifically forbidding the ownership of pit bull terriers or specifically outlawing any one of the defendant's isolated acts regarding the dogs, this did not preclude the jury from finding that the acts of keeping the dogs in the circumstances evidence and leaving them unguarded, all with the knowledge of past incidents, built up to reckless conduct on this occasion. So there, essentially, the defendant did not properly secure his pit bulls. They got out of the house and they killed a child. And that was found to be reckless, and that was found to be the basis for involuntary manslaughter. That case also found that the indictment was not subject to a general demurrer. In Baker versus State, which is 280 Georgia 822, a 2006 case, that case held that evidence was sufficient to support a conviction for misdemeanor reckless conduct when the defendant left his 9-month-old and 3-year-old sons unsupervised on upper floor of a 2-story home near an unprotected flight of downward stairs. Again, did not secure his children away from a dangerous hazard. Reyes versus State 242 Georgia Appellate Courts 170, a 2000 case, held that evidence was sufficient to support a mother's conviction for reckless conduct and failing to supervise a 3-year-old who was apparently attacked by an animal when evidence showed that the mother allowed her daughter to wander unsupervised, and the daughter was missing for more than 1 hour before the mom began looking for her. So again, not supervising her child, not preventing her access to the outside, and that resulted in reckless conduct. Johnson versus State, 341 Georgia Appellate Courts 425, a 2017 case, found evidence was sufficient to uphold involuntary manslaughter, reckless conduct, and cruelty to children in the second degree convictions, where defendant left her 4-, 3-, and 2-year-old children completely unattended for an extended period of time in a room where they were sleeping on a mattress that was placed directly on the floor next to a space heater. Essentially, the court found that the mother knew that space heaters can catch fire, that they barricaded the children in the house so they could not leave. And when the space heater did catch fire and killed 2 of the children, that was found to be reckless and also involuntary manslaughter. So again, they put the children next to a dangerous hazard and did nothing to prevent them from being injured. Johnson versus State, 292 Georgia 856, a 2013 case, held that a jury could reasonably have concluded, based on the evidence, that the defendant acted with willful, wanton, or reckless disregard for her son's safety, both in failing to prevent her son from accessing her methadone medication and in failing to seek medical treatment once it became clear he was ill. So essentially, Your Honor, those cases show that an indictment for reckless conduct is sufficient against a general demurrer if it alleges a crime. The crime here being not preventing his child access to a gun when he had knowledge, when he had warning that his child was dangerous. And if the jury finds that he should have taken the gun away from him, then it is criminally negligent and he can be found guilty of these charges. And the state is just requesting that you let the jury decide that and not grant a general demurrer.
What's your best case on it, Mr. Hobbs? I know it's nothing maybe directly on point.
Sure, Judge. As to, and Mr. Berry will give the court this information more in his argument, but as to the proximate cause, reasonable consequence, there's Bell v. State, which is 317 Georgia 519. That is a Georgia Supreme Court case. And I never know how to say this one, but there's Melancon, Melancon v. State. And do you have the site for that, Mr. Berry?
I do, Judge. I have copies of those. Okay. That I can put in. Yes, sir. Mr. Hobbs, did you want to make any final argument on the specific demurrer?
Judge, I think both arguments are fairly clear, and I think the court has a pretty good grasp of what we're dealing with this. Obviously, this case is a little bit different than the cases that were cited just based on there being a third party in the form of Mr. Cole Craig who actually committed the action which is intended, but I know the court's aware of that and will rule appropriately. Thank you, Judge.
All right, thank you. Mr. Berry, you want to do the general? Thank you, Judge. Good morning. Good morning. The specific, yeah, you want to do the specific. Your Honor, the thing that we know about the indictment in this case is that he's not charged as a party to a crime or as a co-conspirator. So it's kind of a hybrid indictment. In all 29 counts, it's interesting that the language is exactly the same in all 29 counts as to what allegedly occurred. I've given the court the case of Melicant. I think that is the leading case right now. There are a couple of cases that are going up, have been inserted up to the Supreme Court, but I think this is the leading case right now. It was decided in September of last year. And basically what it said, Judge, is that for each kind of murder set out in our statute, the state must prove that the accused caused the death of another human being. In looking at all of the previous cases that led up to Melicant, cause is broken down into two parts: a cause in fact and legal cause, which they have outlined in Melicant as proximate cause. In addition to cause in fact, the decisions describe a separate requirement that they call proximate cause. That's in Bell versus the state at 317 Georgia 523, Eubanks versus the state 317 Georgia 563 and 565, and Jackson versus the state at 287 Georgia 648 and 649. The overall elements of causation required in murder causes is proximate cause, and that elements include cause in fact and legal cause. Legal cause requires foreseeability or likelihood of death happening in the way that it did or alleged in the indictment, which gives the defendant the conduct which they allege. When you look at the indictment based on Melicant, there's some striking things that you see. In the beginning of the wording, they say consciously disregarding a substantial and unjustifiable risk. This is the language that's used in reckless conduct, but they use it in each one of the charges, all 29 charges uses this same wording. The problem is you are using wording from reckless conduct in a murder charge, murder in the second degree, which is very vague. Which one are they talking about? Are they going to argue reckless conduct, or are they going to argue murder in the second? That language should not be in the indictment. Secondly, in looking at the indictment, they indicate that access to firearms is an issue. There's no requirement under Georgia law that people have their guns locked away. I think it's come before the legislature a couple of times. That has not been, no law has been passed in that regard. Even if you lock your guns away, what is access? Somebody can break into a gun case, get the guns out. So what do you mean by access? Is it just that everybody's going to have to get rid of their guns if they have kids under a certain age? We don't know. It's not specific in the indictment. Now, let me ask, so just trying to think of an analogy there. There's no law that says you can't leave your prescribed narcotics on the coffee table. But you could certainly be charged if you left open prescribed narcotics on a coffee table and a child came and overdosed. I mean, would you disagree with that, or? Well, you can take that analogy a lot of different directions. If I have an automobile, I have a 16-year-old, and I know my 16-year-old's gotten a couple of speeding tickets, but I leave the keys in the kitchen. And my 16-year-old gets the keys, drives down the road, runs into somebody and kills them. The access to the keys, is that the proximate cause of the murder? It's very vague at best. And that's why we're saying the indictment is vague in and of itself on a number of levels. That just being one of them. And I realize we have a uniqueness here with the third-party actor. Correct. This is one of the most bothersome parts of the indictment to me, is it says, after receiving sufficient warning, we don't have any clue what that sufficient warning is. I don't know. I've looked at all of the discovery. I don't know what that sufficient warning is. It doesn't outline it in the indictment. So how do I know what a sufficient warning is? Is it your son's having some problems? Is that a sufficient warning? I don't know, because the indictment does not say. So how can we say that a warning is the proximate cause? Because we don't know what that warning is. It's interesting, too, that in the indictment, it alleges that this occurred on or about September the 4th. On or about September 4th. We don't know what sufficient warning he received on or about September 4th, because they put it kind of in a capsule. It's got to be close to September the 4th. We don't know what that warning was close to September the 4th. And was it sufficient? What does sufficient mean? How do we know? Because they haven't outlined it in the indictment. The next part of the indictment, which is confusing, is that Colt would, after getting this sufficient warning, that he would cause bodily injury to somebody. Now, where in the indictment does it tell us that he knew he would? Not that he may, but knew. It's not in the indictment. We don't know how in the world he would have known unless Colt told him. We've got Colt's statement, unless he's made some other statement that we don't have. He's not made that claim. So how would he know that? We don't know. The indictment doesn't tell us. The indictment basically, I think, Judge, shows some conclusions that the state has. But what we have to have in an indictment is primary facts. We have to have some facts to go on. So in this indictment, the reason we've demurred to this indictment especially is that the state's failure to properly allege the probable cause issue. There's nowhere in the indictment that it uses the word probable cause. And two, the state's failure to allege that the death was reasonably foreseeable consequence of the defendant's action. And we don't know whether it's the defendant's action or inaction. They really haven't told us whether it was an action or an inaction that the defendant did in this indictment. Since they were not alleged in the indictment, there's no way to determine whether the grand jury found sufficient probable cause to issue a true bill. Additionally, the indictment lacks specificity as to material elements of an indictment. For those reasons, Judge, and I think the indictment just is very vague. It does not put us on notice of exactly what we have to defend. It does not allege probable cause or foreseeability of this knowledge. So it, in our opinion, it's too vague and should be, either the state can redo it or this should be thrown out. Thank you.
Thank you. Ms. Brooks.
Yes, Your Honor. Well, to begin with, as I stated earlier, reckless conduct in criminal is regarding criminal negligence, and so is cruelty to children in the second degree. The only difference is that cruelty to children involves a child, reckless conduct would involve an adult. So the language can be the same because it's essentially the same charge with the only difference being the age of the victim. Involuntary manslaughter is based on the death of an adult. Cruelty to children in the second, or murder in the second, is based on the death of a child. And I think it's important, Your Honor, when we are talking about special demurrers, that we actually cite what the law and what the standard is. And under State versus Lehman, 279 Georgia 340, a 2005 case, while it says an indictment must be perfect in form, that does not mean that the state has to allege every fact and every piece of evidence that we are relying on in proving our case. What the defense appears to want us to do is to go through each and every piece of evidence that we have and each and every fact that we have, but that is not the purpose of an indictment. The true test of the sufficiency of an indictment is not whether it could have been more definite or certain. It is whether the indictment, one, contains the elements of the offense intended to be charged, and two, alleges the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet. And that's under Hinton versus State, 310 Georgia 388, the 2020 case. In considering whether the indictment is insufficient, it is informative to remember that the purpose of an indictment is to allow the defendant to prepare a defense. It is not for us to tell them everything that we are going to present at trial. We've given them discovery. They know what we are presenting at trial. We are not required to outline every piece of evidence in our indictment. As far as each count in the indictment, the state did allege each and every essential element, which is prong one of the requirements to withstand a special demurrer. So for cruelty to children, those Elements are 1, cause cruel or excessive, 2, physical or mental pain, 3, to a child under 18, 4, through criminal negligence. And here we charge each of those elements. We charge the type of pain, the name of the child, and what act constituted criminal negligence, which is, quote, consciously disregarding a substantial and unjustifiable risk that defendant's act of allowing his minor son access to a firearm and ammunition after receiving sufficient warning that defendant's son would harm and endanger the bodily safety of another. That is his act of criminal negligence. And essentially, it's the same thing for reckless conduct. We indicted each and every essential element that is outlined in OCGA 16560 and charged the defendant with the harm that he caused, the victim's name, and the specific act of criminal negligence. Now, for murder in the second degree and reckless conduct, it's essentially the same elements, but you add proximate cause. And to go along with the defense counsel's analogy, whether or not you know that the 16-year-old driving the car, the dad giving him access to that car, was the proximate cause of death is up for a jury to decide. It's whether or not the jury finds that it was reasonably foreseeable that the child would kill somebody. And that is the same case here. Something is the proximate cause of someone's death if the person could reasonably foresee that someone would die as a result of the actions. Pursuant to Eubanks v. State 317 Georgia 563, a 2023 case, proximate cause requires that the death actually happened in a way that was a reasonably foreseeable result of the criminal conduct. But what constitutes proximate cause is undeniably a jury question and is always to be determined on the facts of the case. And that's Butler v. State 363 Georgia Appellate Court 753, a 2022 case. And for indictment purposes, what that means is that the state has to allege an act that could, under any circumstances, result in the death of another. Under any circumstances, be the proximate cause of the death. That's Graders v. State 263 Georgia Appellate Court 754, a 2003 case, and Funk v. State 296 Georgia 371, a 2015 case. And in this case, the state alleged that the defendant acted with criminal negligence by disregarding a substantial and unjustifiable risk, that is, act of allowing his son access to a firearm, again, after receiving sufficient warning that his son would harm another. The plain language in the indictment requires that harming another by use of a firearm be within defendant's knowledge and therefore reasonably foreseeable. We put the wording in there of sufficient warning. The defendant had to know that his son was going to do something or was capable of doing something in order for him to be responsible for the actions of his son. And that in itself is reasonably foreseeable in the indictment. And going along to the next argument that the state should have been more specific with regard to whether or not we charge party to a crime, what access the defendant gave his son and what warnings specifically he had. Well, again, an indictment does not have to contain every detail of the crime to withstand a special demurrer, and that's Kimbrough v. State 300 Georgia 878, a 2017 case. And again, sufficiency of the evidence is separate and distinct from sufficiency of the indictment, and that's State v. Hart 183 Georgia Appellate Court 737. According to Scruggs v. State 309 Georgia Appellate Court 569, a 2011 case, the state does not need to spell out in the indictment the evidence on which it relies for a conviction. Simply put, the law does not require the state to further define essential elements of the crime. We have to put what the essential elements are. We have to apprise the defendant of the evidence he is to meet so that he can prepare a defense, and the state has done that. And I want to go through some examples. Again, we have a unique set of facts, but we have a lot of cases, a lot of charges from where additional facts are not required. So you have Hinkson versus State, 310 Georgia 388, and Arthur versus State, 275 Georgia 790, which hold that for aggravated assault, an indictment need not say how the defendant used the weapon or even what that actual weapon was. So to say that we have to put the exact warning and the exact access would contradict the fact that you don't even have to put what the weapon was in an aggravated assault. State versus Tate, 262 Georgia Appellate Courts 311, which is a 2003 case, found that a terroristic threats indictment only alleging the crime of violence that was threatened as opposed to the actual wording of the threat was sufficient. So all they had to say was, did threaten a crime of violence, to wit murder, and that was fine. They didn't have to say exactly what he said. They didn't have to say the means of communication for the terroristic threats. In Snyder versus State, 238 Georgia Appellate Courts 55, a 1999 case, an indictment for cruelty to children and child molestation did not allege the specific immoral and indecent act that constituted child molestation and cruelty to children. And that was found sufficient. So they didn't even have to say how the defendant molested the child or caused the pain, and that was fine. In South versus State, 268 Georgia Appellate Courts 110, a 2004 case, that was an aggravated stalking indictment that was sufficient even though it didn't allege the exact ways in which the acts of aggravated stalking occurred. So in this case, the state has put the defendant on notice, the incident date, and he argues that we did not provide a detailed date or that the date isn't sufficient. Well, what the date is the date that the defendant giving his child access to a gun resulted in people dying and people being injured. That is the date. We didn't say the date of the warning. It was what knowledge he had at the time he allowed his child to have access. And that is the date, and that was September 4th of 2024. They are on notice of the date. They are on notice of the specific victims' names. They're on notice of the act that the state is alleging was criminally negligent, again, giving his son access to a firearm, not taking it away when he knew that his child could harm others. And we allege that the defendant's actions were the proximate cause of the deaths of Christian Angulo, Mason Skirmahorn, David Aspinwall, and Christina Yermy. Specifically with regard to party to a crime, the state doesn't have to allege that. That is long settled law. There's no requirement that we put in any sort of indictment that the defendant was a party to the crime of someone else's actions. So that is under Leaks versus State, 303 Georgia 104, a 2018 case. Indictment did not need to be charged with defendant's culpability in it to be proved in that manner. That is also Metz versus State, 284 Georgia 614, a 2008 case. The law is well settled in Georgia that the state is not required to specify in the indictment that it is charging the defendant as a party to the crime. Specifically with regard to the warning that the state alleged, indictment after, or charge after charge has the phrase knew or should have known in it. And the term sufficient warning is analogous to knew or should have known. Statutes like theft by receiving under OCGA 1687, which requires the defendant knew or should have known the property was stolen. Drive-by shooting under 1615 4.1 requires the defendant knew or should have known a building at which he fired a gun was occupied. Or harming a public safety animal, OCGA 1611-107, that requires that the defendant knew or should have known the animal harmed was a public safety animal. There's no requirement in the law that demands that the state allege what knowledge the defendant had in each of these cases. And it's the same in this case. There's nothing that says the state has to prove these specific warnings or the specific knowledge that the defendant had when he let his son have a firearm. Requiring the state to outline each and every warning that the defendant had would not only make this indictment entirely unwieldy and just pages upon pages long, but it would also require the state to prove elements that is not required to under the law, and it would give us a heightened burden of proof that we are not required to have. Ultimately, it is for the jury to decide whether the evidence presented is sufficient to prove that defendant's knowledge and actions rose to a level of criminal negligence. And the state respectfully requests that the court allow the jury to do that and deny the special demurrer.
Thank you, Mr. Berry. Thank you, Judge. One thing that the state didn't talk about is this new case, Melancon. It requires that you allege proximate cause. They don't do that. They don't say that because he got this notice, that was the proximate cause of the death. Because of the access, that was the proximate cause of the death, or foreseeability. Both of those are outlined in the Melancon case, and I think that certainly it's very important. And we don't expect, and we know that indictments are not perfect. However, you are to put in an indictment what you allege that you're going to prove. You have to put us on notice what that is. And if you read the indictment, and they say some of the cases say it's just known that it's new or should have known, that's not what's in the indictment. That's very specific. He knew because he was given specific warnings on or about him. And they said, well, we don't have to put exact date that he got the warning, but that's not what the indictment reads. The indictment reads that all of this was on or about the 4th of September. So we have to assume that that notice was given on the 4th of September because that's what's in the indictment. No knew or should have known. And I think when you read the Melancon case, which is a case from last September, it's the most recent case. There are two cases that have gone up to the Supreme Court with similar situations. They have not been decided yet, but this is the leading case right now on what proximate cause, what you have to show in proximate cause. And none of the things that they put in that case are alleged in the indictment. And we still believe, Judge, that they should give us some information as to exactly how this specific warning was given, by whom to him, when he got it, how he got it, what that warning was. I mean, how do we argue proximate cause if we don't know what the warning was? It's not in the indictment. So we're not asking for a perfect indictment. We're just asking for one that we know what the heck we gotta argue. And that's what we don't have. Thank you, Judge. Thank you.
And Your Honor, I know he gets a lot of words, and you're correct with briefing this statement. The Melancon case is not a case about a special demurrer. It's a case about sufficiency of the evidence. It doesn't outline what is required to be in an indictment. It outlines what is required for the state to prove at trial for proximate cause. Again, it's sufficient of the evidence, and that is not what today is about.
To make sure you get last word, go ahead. Thanks, Judge. And that's correct. However, it outlines what it is. And obviously, if you don't have that in the indictment, you got to go back and say, okay, that should have been put in the indictment. So even though what they say is true in one regard, it's still the law that you need to put it in there now, because that's what Melancon said.
So I know the state just this morning in open court filed their brief. What are y'all's opinions on submitting proposed orders?
Your Honor, we can do that. We can adjust.
I assume you can turn your brief into one. I don't know about their defense.
Like it's the
10 days to file. That's okay. Yeah, schedule an order.
We can certainly submit a proposed order, Judge. If you would like us to submit a brief, we would simply ask for about a Monday. We can have a brief to you on it pretty quickly if you'd like one.
The proposed order citing the law and such would be sufficient if you're okay with that.
We are.
Thank you. I missed how long you wanted for that.
How about a week, Judge?
Sure.
Thank you.
All right. So I'm just been handed the scheduling order, so I could look at that. So number 1 says all discovery in the possession of the state be served on the defense on or before June 16th, which is yesterday.
Yes.
Where do we stand with that?
We served everything that was in our possession. I think there are a few outstanding things that we requested that we have not gotten. I don't think it's a significant amount, but the majority of all the items that we are going to get have been retrieved by the state, have been served on the defendant. Obviously, we'll be serving jail calls on an ongoing basis, and if there are any additional witnesses we come upon in interviews, we will serve those as well.
What sort of evidence you say you don't have yet? I want to make sure we don't run into a situation where they're handed 1,000 pages of.
We have a list. So the majority of the stuff that we're still waiting on, we're waiting on a few medical records from some of the victims, which won't be much to see. We are waiting on some certified copies of search warrants, there were some additional school records of the defendant's son that we had not received, where he had been at for a short period of time. We were waiting on those. And I think the only thing that appears to be a little bit more lengthy would be call detail records for the defendant. We already have provided what we have. I think we've asked for some additional call detail records, and those have not come in yet.
Do you have any kind of estimated timeline of when you're going to? I would think school records.
School records should be, I know we've received emails back from the school saying they are working on it. So we assume that'll be hopefully this week. Medical records, usually those are pretty quick. We've been working on those for a while at this point. And then as far as the CDR records, we did do a search warrant. I think it was maybe a month ago. It's been 3 weeks ago. So that should be soon as well.
Okay. I know y'all will be, but just continue to be diligent in accessing that so that the defense has it in a timely manner.
Yes, sir.
I realize y'all don't have all the discovery, but what other anticipated motions do you believe we're going to hear?
Judge, I think we've got some motions to suppress that we're going to be filing.
Okay.
And there are some that we'll need to speak with the court without the district attorney present, dealing with psychiatric situations. So
I just want to make sure, obviously we're scheduled to commence the trial September 8th. I want to make sure that we have time to get in court, argue the motions, time to rule on them. If things get tight in the summer, there's a judges conference 1 week towards the end of July, vacations, but okay. So we do need to confer and maybe just go ahead and get do we have a backstop already for a day to argue those motions? Have y'all talked about that with Mandy?
we have, Judge.
Okay.
She gave us some additional dates other than this one. So if those are still available, we can look and come up with a date.
Do you anticipate any of the motions taking more than a day or half day to present and argue?
I don't think so.
Okay.
And Your Honor, it won't take long to prepare the motions, it's just more of a matter of witness availability. So the sooner we know, obviously, what witnesses would be required, then the sooner we can make sure that they're available for whatever day.
All right.
Maybe after our deadline of the 15th, we'll try to come over and sit down with the state.
Okay.
See if we can go through some of those ahead of time.
And then, and I'm certainly okay with y'all filing them before the 15th. All right, and y'all filed a motion to reconsider the change of venue, is that right?
We did, Judge.
Y'all want to address that?
Yeah, sure. We'll take a minute. Judge, we're concerned over where the court has chosen to move this case, Hall County. Hall County is contiguous to this county.
At a tip, but go ahead.
It's still contiguous, at least in our perspective. It is.
Yes, sir.
The thing that we're concerned about also is some of the witnesses in this case are from Hall County. Hall County was where they raised about $50,000 through their T-shirt. They were done in Hall County.
Tell me more about that. I don't remember hearing Hall County with a T-shirt fundraiser.
We had argued it initially, Judge, some of the business people there in Hall County did the Appalachian Strong T-shirts.
As in the company made the T-shirts, or there was a in the community fundraiser there?
Well, they made the shirts there and of course sold them there.
Okay.
And as I understand, it was about $50,000 that was raised from the making of these T-shirts. The primary concern that we have is that demographically it doesn't match. It's in the same, well, you got the same news programs there as you do here. So we really haven't changed anything much except this very small epicenter. And I would venture to say it probably doesn't take much longer to get from this courthouse to the Jackson County Courthouse than it would to get here to the Hall County Courthouse. I don't know, I haven't driven it, but it's pretty close. And I assume if the court does Hall County, that you'll allow people to drive back and forth from Hall County here every day.
So I will discuss some logistics with y'all a little later. I will make arrangements. Go ahead.
But that's what our concern is, Judge. It's just not far enough away. I think that we're still in that epicenter of where this occurred. And I think that you're going to have people in Hall County as a neighboring county. You know, it's a tip, it's still neighboring county. And of course, the other county in your jurisdiction covers a lot more of the territory. It's in the same jurisdiction.
Right.
So we're just very concerned about that. I know the court wants to try to accommodate everybody and do the right thing, but we feel like that we need to be a little bit farther away. This is just too close. We're demographically not the same. And
is there a case that says the demographics are a problem? And specifically, when you say the demographics aren't the same, is there a specific allegation there?
Well, the percentage of black white is different.
How different?
See if I've got my notes on it. I don't think I wrote my notes up on that.
Because I think the percentage of at least white is the same or a percentage less than at least one of the counties suggested by you guys in your original request for South Georgia.
I think from the standpoint of the number of people, they're about 2.5 times. Or
it is a bigger population.
Correct.
No question. So obviously I reached out to, it's in the order, I reached out to the South County Georgias that were recommended by the defense. None of those were going to be able to accommodate us, certainly not on our September trial schedule. Now, if we went into 2026, one of them seemed more likely to be able to try and make it work. So the trial dates present some problem. We're also talking about, I'm being told, a 3-week trial. So we're also talking about disrupting the lives of jurors, which is going to be a big ask for 3 weeks or so. And what we want is to not have a jury get, once they're seated, not get tainted, not lose jurors for any improper conduct or improper information that they've received outside the trial. So I really was reluctant and am reluctant to put jurors in a hotel for 3 weeks. So that means with that in mind, that means I need to be able to get the jurors here in a reasonable amount of time and back each day. If I put them in a hotel, I don't think that we've eliminated the problems that we have with sequestering a jury unless I take their cell phones away. And I can't imagine in this day and age taking the cell phones from jurors for 3 weeks. So I think, and again, I may prove to be wrong, but I think allowing them to continue some normalcy of life increases the odds that we don't have jurors do something they're not supposed to do over the course of a 3-week trial, which did limit how far away I could go. Now, the other looming problem is finding some other place that can accommodate us for a 3-week jury trial. We had kind of already earmarked some time here and were able to arrange things, which is, I have more control here than I do anywhere else. Normally, and correct me if I'm wrong, but in a change of venue, you usually go through where the crime occurred, trying the case where the crime occurred. In other words, here in Barrow County, we're doing jury selection, and then we find out too high a percentage of the jurors can't be impartial. So we're removing that, at least in some degree, by bringing jurors in from somewhere else. I realize it's not as far as you would like. And certainly we may be in jury selection and find out that too many of the jurors there can't be impartial. And that puts us where we would have been if we'd have tried to get the jury here. Either way, whether I try and find somewhere else, which is going to be 2026, or we try it with Hall County jurors and find out that perhaps we can't get a fair jury there, we're still going to be 2026 going somewhere else, doing it again. I realize, and I knew the order wouldn't make everybody happy, and I realize that it may ultimately prove to be a bad decision. But I think it's worked, since we already have plans to try this in September. We have the ability to do it here. I think it's worth getting a jury from somewhere else that's close enough to get them here and back every day without them having to stay in a hotel for 3 weeks. And if I'm wrong and we find that out in those 3 days of jury selection or 2 days of jury selection, then either way, we're in 2026 trying this thing. And if it happens that we can't get them in Hall County, then I'm much more likely to try and go to South Georgia or make plans in advance where somebody can accommodate us. So I certainly understand the motion, but I don't intend to grant it.
And, just to let the judge know, I know you want to get it tried in September of this year. But there may be some impediments to doing that anyway, depending on what we may want to take up. So if we do that, it may put it into 26 anyway. So if that's the case, then I've been doing this for a minute. I know what it's like to spend 2.5 weeks of voir dire and not be able to get a jury. So I certainly would like to avoid that, and I know everybody would like to avoid that. I know you want to accommodate the VA's office and the witnesses. We drive 1 hour and 45 minutes every day to get here.
Yes, sir.
So, that's not outside the realm either. Maybe we could go up towards Chattanooga. They don't have the same news media coverage to get it out of Chattanooga instead of Atlanta. So I just want to keep that open for the court if you see that we may have to go on 26.
Yes, sir. And well, I'll keep that one to myself. If there's anything that y'all see on the horizon, either side, that is going to be an impediment to trying this as we have it scheduled, let me know as soon as possible, because if we do need to make changes, I want to know about those as early as possible. We've put a lot on hold here for the 3-week trial, that if we're not doing it then we can adjust the court schedule here so that other cases can be tried. Okay. I do have just some logistics to discuss if council are comfortable coming to chambers after you pack up here.
Yes, Your Honor.
All right. Thank you.
Thank you, Judge.
Yes, sir.
Absolutely, nice to meet you. See you? Yeah, Brian.
Ladies and gentlemen, I've been informed that the jury has reached a verdict. Anything from the state before we bring the jury in?
Nothing from the state, Your Honor.
Anything from the defense?
Nothing from the defense, Your Honor.
All right, ladies and gentlemen, those of you who are with us, I give this instruction every time before the jury comes in. And that is simply to let you know that we cannot have any type of outburst or anything of that nature, regardless of what the verdict is. This is just simply to let you know that if you're unable to contain your emotions, you need to excuse yourself from the courtroom now. Because regardless of what the verdict is, there's to be no display or no outburst or any sign of emotion whatsoever. All right, so if you need to be excused, you can go ahead and excuse yourself now. All right, let's go ahead and bring the jury in. Ladies and gentlemen, welcome back. I understand the jury's reached a verdict, is that correct? All right, and have you written the verdict on the indictment, signed it as the foreperson and dated?
Yes.
All right, if you would please hand it to the bailiff. All right, I'll ask the clerk if she would please publish the verdict.
Indictment number 2021 GS 2601191. The state of South Carolina, county of Horry versus Megan Marie Jackson as to the charge of murder, we the jury by unanimous consent find this defendant guilty. Signed by foreperson Jeffrey Roberts, dated June 17th, 2025. Ladies and gentlemen of the jury, if this is your verdict, please so signify by raising your right hand. Thank you.
I let the record reflect that all jurors raised their right hand. Any polling of the jury by the defense?
No, sir.
All right. I All right, ladies and gentlemen, I want to thank you for your service. That will conclude your duties as jurors in this case and for this term of court. And I want to thank you for your service. I know jury duty is not a fun thing to do, but it is an important thing to do and a vital thing to do. You have a 1-year disqualification from serving as jurors in state circuit court. You've got a 3-year exemption. I hope you don't exercise your exemption because you do need good jurors. And I want to thank you for your service.
Sorry, I'm back, everyone. Sorry. I'm back. Hello, everybody. Hello. So sorry about that. Stephanie, see you very soon. I'll text you. Sorry about that. I had to run out with some milk for the baby. And I'm really, really sorry for that. But I'm back. The last thing that we're going to do, because then I did say it was going to be a short stream anyway, but I did promise to show the body camera video of the Colin Gray situation before we do go. So I'm going to put that on and then that'll be it. But I do apologize for this, but I'm literally running again. Today has been wild. It's been a great day. But now we're going to watch the body camera of this body camera footage shows the interview of Colin Gray on 2020 through 2023 on a school incidents online threat. So yeah, thank you for understanding, y'all. You guys are the best. Thank you very, very much.
Are you Colin? I am. You want to step out where we can talk real quick? You got a son or something that uses, you know what Discord is? No. So we got a tip from the FBI saying that somebody from your old address over there in Traditions had made a threat to shoot up a school. For real? Yes, sir. And your name was associated with that address. So we went over to that address and you weren't living there, so now we live here. Let me get dressed. Sure. Why is there a door in the underwear?
Working nights.
Yeah.
I at least wear pajama bottoms when I answer the door. At least try to.
Come to the door in my underwear.
Unless it's in the middle of the night. I usually have a gun in the hand.
Yeah.
A gun in my hand.
Different story.
Yeah. Yeah. I had a thing over on Davenport Road.
Mm-hmm.
Guy had stumbled through this person's yard, knocked on the door, dropped. When he left, he walked through a fence and tumbled into the ditch, lost his phone. So I picked his phone up, and it was one of those last calls.
Mm-hmm.
So I put it in an evidence bag, and I was like, and it was on the weekend, so I was like, nobody's going to be messing with this.
No.
So I put it in an evidence bag, forgot to take it by the office, went home. I had somebody showing up on my doorstep at 2 o'clock in the morning, beating on the door. Wife comes in there and like, hey, there's somebody at the front door. Went out there, they were gone, but I called Griff.
Mm-hmm.
He came out there and checked it out.
Sorry, boys. That's all right.
Yeah,
Sorry. I got up watching the golf tournament and sat back down. That was it.
Yeah.
So what? Tell me what. You have any kids or anything living here?
Colt Gray.
Colt?
Yeah, Colt. He's my oldest son.
How old is he?
He's 13.
Does he play a lot of video games and stuff?
Yeah, he does. Play all the time.
Is he here right now?
Yeah.
Okay. You think it's something he might have?
I damn sure want to know.
Can you talk to him?
Yeah, absolutely. Now look, he gonna get all red face when you talk to him. Just calm. All right. So him and his. Let me give you a backstory. So we lived over at Traditions.
Mm-hmm.
I went to work one day. I'm sole provider. Build high rises downtown.
Mm-hmm.
So I get a call from one of y'all. So my family's in law enforcement. So when I get the call, I'm trying to think the officer's name. Turns out, nicest guy ever. He's like, I just want to let you know I'm at your house. I'm like, for what? He said, y'all have been evicted. I'm like, no, I just paid rent. He's like, no. He's like, I'm going to stay here till you get here. So I drove all the way home. all my shit's in the front yard. And I'm like, what are you doing? He's like, I'll just let you know this is what's going on. There's people standing there with trailers and shit. And I'm like, what are they doing? He's like, well, they're going to get your stuff after 24 hours. Is that right? Like, I don't even know why y'all are here. So, long story short, I'm like, trying to figure out what's going on with my wife. She's in the house. So we split. Long story short, for obvious reasons. She took my younger two and went back home, lived with her mom. Colt and I rented a house and came here. So we've been good, like no problems. He struggled at first with the separation. All school was kind of so. So I've been up at school countless times, just tracking with him. You know, like, hey, make sure you're good. They understand what's going on.
Jefferson School?
He goes to Jefferson Middle School, yes, sir. So he's been doing really good. Like, you know, in the beginning, he kind of struggled a little bit. But
let me ask you this: Do you have weapons in the house?
I do.
Are they accessible to him?
They are. I mean, there's nothing loaded, but they are down. We do a lot of shooting. We do a lot of deer hunting. He shot his first deer this year.
Yeah.
You know, so like I'm pretty much in shock, to be honest with you.
Well,
I'm a little pissed off, to be even really honest with you, if that is what was said. But
well,
we've been up to school for so many times now.
The information I got was sort of incomplete. I don't know how old it is. And like I said, the original complaint went to your other address, or your previous address, and that's where we just came from. It wasn't them.
Yeah, no, I'm sure it wasn't.
I don't know if it's so we ran I had your name and date of birth, so
yeah,
that's how we got this address. So
I mean, I swear to God, we've been up to school. I've been up to school, like, I'm on first name. I just was up there 3 days ago for his finals, talking to the principal, like, look, make sure Colt's good. He gets flustered and under pressure. He doesn't really think straight. Can we just, just kind of put your arms around him, get him through 7th grade? I just want to make sure he's good. Like, I mean, we're up there all the time talking to school. Okay. If you talk to that school, they'll know exactly who I am. I'll say that. Okay. I mean, because I'm up there that much. Yeah.
Checking in on him.
Yeah.
Sure.
I just want to make sure he's good.
Yeah.
So I'm a little taken back by the whole thing, but I can tell you this, I take that very serious, and so does he, as a matter of fact. He's...
Say his first name's Colt?
Colt, C-O-L-T, yes, sir.
I mean, all I can do is ask him.
Yeah, well, absolutely. Yeah, I want you to talk to him and just tell him. Like, I don't know, I don't know anything about him saying shit like that, and I'm going to be mad as hell if he did. And then all the guns will go away. And they won't be accessible to him. I'm trying to be honest with you, I'm trying to teach him about firearms and safety and how to do it all and get him interested in the outdoors. Mm-hmm. Like on my phone.
Get him away from those video games.
Exactly right. That's the God honest truth. And the picture on my phone is him with blood on his cheeks from shooting his first deer. It was just the greatest day ever. Yeah, so he knows the seriousness of weapons and what they can do and how to use them and not use them. So it's kind of a little bit of a shock. So in whatever y'all are telling him, please instill in him that if this is whatever, wherever this is coming from, it's no joke.
Yeah.
Like, it's no joke.
But we wouldn't be here if it was.
No, I know. And I'm telling you right now, we talk about it quite a bit. Okay. All the school shootings, things that happen.
Yeah.
Hey, are you getting picked on at school? He is. He's getting picked on at school. And is everything okay? That's why I keep going up there. Yeah. Because you never really know. And I don't want anything to happen to him. So. Mm-hmm. Yeah, y'all.
All right, well, if you want to grab them,
yeah, y'all talk to
or we can go in. It's
all cool. Hang on.
That's the worst part about it. I don't remember
What information? Yeah.
These are good dudes, just, they're
Hey
told.
Cole, what's going on, bud? So did your dad kind of explain everything to you?
Said something about
Shooting up a school.
Did you say something about school shooting?
Never, I just told him, I don't know what, maybe they misheard somebody else, I would never say that.
You never ever said.
No, I swear.
Do you use Discord?
Discord?
Yes, sir.
I used to, I don't have it.
When's the last time you used it?
Like a few months ago.
Really?
Was it at Traditions or was it here?
No, it was a Traditions because in that Discord account that I had deleted it before
Before you moved here?
Yeah, because I think it got like amen password pulled or something. Like I clicked on a link and somebody.
Have you heard anybody on Discord when you were using it say something like that? You remember?
Like at that time?
Yeah.
I don't think so. I don't think I ever had anybody that.
Never. And I mean, I'm not trying to get anybody hemmed up, but like this is some serious stuff.
Yeah, I know.
Oh, he knows how serious it is, trust me.
Because I'd hate to, my boss was even like, I don't know how old this information is, and if you want to wait till Monday to follow up, I was like, nah, I'd rather do it now, because
so would we.
Because God forbid something happened and I didn't do my job, I'd feel pretty bad about that. So I just want to make sure you understand that if something like that happens or you hear something like that, report it.
Yeah.
Tell your dad, tell teacher.
Like I told him, I would promise I would never say something.
So you haven't used Discord in a few months,
No,
and you're saying you didn't say anything like that.
No, the only thing I have is TikTok, but I just go around there and watch videos.
Okay. All right. Well, fair enough.
What's your birthday?
He's just gonna do a little report saying that
We
what
talked.
we've done in reference to this, and that we talked, and you saying that we didn't say anything like that. And I gotta take you at your word, and I hope you're being honest with me. I'm not saying you're lying, but it's
serious thing.
It's not unusual for people to lie to police. Okay.
He's familiar with that too.
Hey, Colin, what's a good phone number for you, sir? Okay.
How's school going?
It's going good here.
About ready to get done with it?
I actually already finished. Yeah.
Oh, you did?
Yeah.
When was your last day?
Today Sunday, so Friday.
Friday? What grade you going into?
8th grade.
8th grade, almost high school, man.
Yeah.
The last 4 years, really, the last 4 years is what matters.
Yeah. I'm just focusing.
Get them good grades, man. It'll set you up for the rest.
Yeah, so look, you all are welcome any time. We take it like dead serious around here, and I just want to make sure that I'd even feel better if you do find out what or where.
Mm-hmm.
Like, can somebody let us know? 'Cause
sure.
He's gonna be full of anxiety until this gets resolved. I can tell you that right now.
I've never really said something related to.
Yeah.
So did you switch schools when you moved from Traditions? Where were you going before?
West Jackson.
West Jackson Middle? Okay. Is things a lot better now?
Oh, yes, sir.
Okay. That's good.
Let me grab you one. Can I walk through the grass? I'm gonna grab a car real quick.
Yeah, it's all good.
Are you getting bullied over there at West Jackson Middle?
That's the thing. I wasn't back there. I wasn't getting.
Now look, be honest with him about now in middle school. I told him you were now, and that's
You getting switched out halfway through the school year, being the new guy?
Yeah, I'm being that while. We moved like 6 times already. So.
Well, my dad was a logger and grew up in the military. We moved a lot when I was a kid.
But
So.
in the past schools, surprisingly, I had friends. Like I didn't necessarily have a reason that I would say that.
Yeah. Yeah. Well, there's always somebody you can talk to if you need to.
Yeah.
School resource counselors.
Yeah, and I do talk to them. Yeah, I talk to the counselor quite often.
Okay.
Just let her update her on to tell them what I show them and stuff like that.
Yeah. Start looking out, making goals for yourself.
Yeah, I'll do that.
You interested in anything?
Well, I'll be a philosopher on the world.
A what?
A philosopher.
A philosopher.
Yeah. It's kind of a out there thing.
Yeah. Well, I mean, do what you enjoy. I mean, I did 20 years in the military. You don't have to settle on just one thing. Did 20 years in the military, retired from that, and been doing this for 7. So you don't have to fit everything inside the box.
Yeah, that might branch out to different stuff.
No. We got guys at the sheriff's office, they're full-time plumbers, full-time police officers, and, you know, do what pays the bills, do what they enjoy. But everything's going good.
Yeah, now, yeah. Sure.
Well, that's good. You got a phone?
The iPhone, yeah, I have a phone.
What's your phone number?
Like I said, I changed my phone number.
Okay. All right. Dad said you went deer hunting for the first time this past year.
Oh, yeah.
What'd you get?
3-pointer.
3-pointer?
Yeah, it was nothing much, but I still.
Fork on one side and one on a prong on the other, or?
It was one on one side and 2, 3
Yeah.
so yeah.
Yeah, fork on one side and one on the other. Spike.
Yeah, 4.
Yeah. I've probably seen more one antler deer this year than any other time in my life. Out there in rut and breaking off an antler. Run around with just one set of antlers.
Grass about as high out here. So, anyways, all right. Well, look, Colin, I appreciate it. Your dad's got my card. If anything, if you hear anything, tell your dad. Okay? He's got my number. He'll pass the info on.
It's serious. He knows how serious it is, and he'll, like I said, we'll have a long conversation here in just a little bit. And if something, it's a pretty traumatic thing that him and I both went through. Now he was at school, I was at work, come home, and I mean every ounce of what we had was under tarps and sitting in that yard. You saw it.
Yeah.
You saw the clientele, the neighbors that lived there. It was like fully embarrassing. So it was very traumatic for both of us. And living here, just us, is like dust is finally settled. He's making good grades. So
that's good. We'll keep that up. That's important.
We'll start talking about traditions in West Jackson and just see if something jogs his memory like that. But certainly we'd like to know if you do find.
Well, my thing is this. So more than likely they track the IP address.
Okay.
And that's why we went to that address.
Okay.
Because the IP addresses are usually location specific.
Yep.
Within an area. So if it came from that house, then either somebody there is lying or the information is just so old.
Yep.
And maybe it was something he heard or did on Discord months ago. I don't know. I have no idea.
Okay.
So, but he's telling me he didn't.
Yep.
Telling me he can't remember anything like that. And I take that at your word. Okay. If you look me in the eye and you tell me that's what you're telling me, I got no choice but to take that at your word right now. Okay. Yes, sir. But like I was telling your dad, if you find out otherwise, then it's a different story. Okay.
It's a really different story. Okay.
Got any questions?
No, sir.
You have any questions? No, sir. All right. Y'all enjoy the rest of your day. Thank you. Appreciate
it, sir.
Y'all be safe.
Good luck to you.
We'll knock out a report. You want me to do it?
It don't matter. It's just going to be information. Our agency assist made contact with these people. They had no idea. The husband said that he hasn't been on Discord and since fantasy football. And, and then Colin made contact with him and then brought his son, got his date of birth, brought him out, spoke to him. Apparently he was getting bullied. Very soft-spoken, reserved kid.
Yeah. Pretty much unable to substantiate anything at this point.
No.
And until we get more information from
I
this
got-
so-called tip from the FBI,
We got Dad's phone number, so we'll just do an agency assist report for the FBI and write it up and we'll be done.
sounds like a plan to me. I appreciate you helping me out, man.
Hey, no worries. You take care, man.
Oh right, so that was it. That was about the camera for the Colin grade. This happened in May 23. The school incident happened in September 24. So roughly a year after this talk. They say they're gonna try follow up, but sometimes it's impossible. Or they did and did not see any signs, and what happened. But yeah, so this was what I had set out and planned for today. I'm sorry it has been a bit confused, and I know, right, William? Absolutely nice house. I like that. Little did they know. Yeah, indeed, Cindy. I absolutely agree. You're absolutely welcome. I like doing this short stream sometimes, especially when there's no trial or anything. It's fun still to engage with y'all, and then I can spend some time now with Garden Bot and Anya and my niece. So yeah, I think that's gonna be it for today. I really, really appreciate every single one of you coming in today, supporting the channel, being here, talking, engaging. Oh, thank you. Oh, thank you so much. It's awesome people here. Absolutely, Cynthia. Oh, I am not the last name. I'm gonna butcher it, and I'm sorry. Sweezy, Sweezy or Swayze. Sorry. I apologize. I'll just call you Cynthia. I think you know. It's fine. Sorry about that. My apologies. Me and last names are, yeah. It's my yeah. Never mind. But I'm gonna enjoy. I am gonna go tomorrow we're gonna do something sort of the same uh, la- uh land type thing. We're gonna do it for. Oh, you got it! Awesome. All right. Thank you very much for that. We're gonna do something compared to today. I'm gonna investigate what to do probably tomorrow morning or later on, because today's date night. Because of yesterday of Karen Reid verdict and all the craziness, we postponed date night for tonight. So I'm gonna wish you a good afternoon, evening, morning, wherever you are, and have a great day. We'll see you all tomorrow. Bye, everybody. Thank you very much for all.
And I'm a real-time crime professional.